Let's see.
2 weeks after the
Plus
vacation.
CBI has filed a report, but it is for
Lordship,
final adjudication.
under the compelling circumstances, Lordship, may I be allowed to mention one material to item number 433. That Lordship,
To mention one new contempt application, my lord, for inclusion in the list. I have annexed the order and the case status, your lord.
Take the order.
And all the file where it is lying at, that I have also mentioned, my lord.
ওটা কি বলো এমএসসি অ্যাপিল ওরা কি ওই কোর্ট ডিসাইড করবে যে আমরা কিভাবে করবো, কবে রেকর্ড দেবে তবে হবে? কারণ রিকুইজিশন যাচ্ছে আসছে না কেন রেকর্ড? বলে দাও, এরকম করে তো হবে না। 24 তারিখের মধ্যে কিছু ফুট আপ হলে ওটা বলবে, পরের দিন আমি করবো। আমি লোককে বলে দিলাম, সে সাপ্লিমেন্টারি লিস্ট করেছে। 2 months.
Yes, ma'am. My lord,
কি মে দুটোর সময় টাইম দাও।
obliged. My lord, it
Doc.
will come on monthly list.
হ্যাঁ, মান্থলি লিস্ট রাখো না।
Obliged.
টেক ইট আপ আফটার দি ভ্যাকেশন, টেক ইট, ডোন্ট।
I'm the petitioner. This is that matter where the petitioner was a TET qualified candidate. There was a High Court order directing me to give a certificate. That was not given when I came before this honorable court for the very first time. Before they did not even.
Yes.
May I be served a copy of the report?
Yes. এটা কি লাগিয়েছি? ওটা তো সাপ্লিমেন্টারি রিপোর্টের কপি।
A bare statement that this is false. This is a bare statement, nothing else.
What required, my lord, I am asking myself.
Well,
The authority is saying this is
let-
not
let-
our
let
document.
it be
Not
investigated. In that case, let this be investigated and let one seat be kept vacant and let this be investigated by a
Only one
central
seat will be
agency.
kept vacant on the
But,
basis of your name is not appearing.
Today this is a violation of a court order. There's no till date. There is no recalling application, no appeal from an order which
Not
has
required,
directed.
my lord. Not required at all.
What not required? Even if this is the direction of court and the direction of the court cannot be taken so lightly. Let an investigation be there by an independent agency, my lord, into this, and in the meantime,
The
at least one seat.
fabricated document, they say, by way of an affidavit. So FIR will be initiated against the petitioner.
My lord, let it be initiated, let it be investigated.
I
But
will ask the
what
court
if
to file an FIR against you, so that it may be investigated.
till date not done? This
I will directly
till-
file an
yes,
affidavit, file an FIR against you. Since
yes,
there is
yes,
a fabrication of the
that may be done. That let the investigation continue. But what if in the investigation it is found that it is not forged? What happens then, my
and
lord?
we'll see.
But that will at that relevant point of time the panel gets
Then we'll
expired,
see.
and
If
I am.
then their direction will be given. The writ petition will dispose of directing them to file an FIR against you.
Let the writ petition be pending, and let there
No,
be a limited
no
time for
pendency of
the
the writ petition.
investigation.
No,
Otherwise,
It has to be
today
investigated.
there is a violation of this of an order passed by this honorable court. My lord will kindly appreciate that there's no appeal, no recalling from that order. The first writ petition, in the first writ petition, my lord will kindly see the order for once, my lord. Page 35, no whisper about this.
35, page 35 was subject to the availability of records that were
Yes.
submitted by
My lord,
Mr.
that is
Vishal.
why, my lord, he was directed to hand over
He
the
was
papers
gone
to
into by
me.
the court.
Yes, I have handed
The
over the
direction
paper.
was given subject to availability of
Yes,
records.
Yes, my lord.
Now they say that it is fabricated.
How
Nothing
to
is
say,
available.
when do they say? After I come to court, I give them the records on 24th March 2025. My lord will kindly come to page 36.
Even if you
Thereafter,
come
no
or
whisper.
don't come, the fabricated documents will not be legalized or regularized.
Fabricated documents cannot be legalized, but
Then-
whether it is fabricated or whether the issue of fabrication is a product of afterthought, that needs to be adjudicated, my lord. Whether the issue, whether the contention that the document is fabricated is a product of afterthought, that needs to be adjudicated, my lord. This cannot just a mere allegation. So that can my lord knows that this happened in even the SSC 2016, that favored candidates were put in, people
Well, kind
who
of-
were out of favor,
My lord,
they
kindly
were not
take
vote.
the board to, my lord, take steps immediately, my lord.
Yes. The board should have taken steps if it was genuine. The board would have taken steps. They have not taken steps because this is a product of afterthought, my lord. Would have taken steps. But it will humbly pray that this may be a limited time, and this much, my lord, I'm humbly praying, my lord.
What
The
limited time?
investigation may be completed within a limited period of time. Otherwise, it gets completed after 20 years. I'm left with nothing, my lord.
Even today, my lord, the list of the, my lord, the successful
14.
candidate is in the website of the board.
Yes, sir.
But his name is not
20
featuring there.
24th March 2025 was this communication. No FIR, no complaint, no
Board
reply that this
receives
is
every day, my lord,
fabricated.
thousands of, my lord, communication. My lord, is it the possible of the board, my lord? I'm asking myself.
Not possible. The board can illegality. There will be fraud. Fraud documents will be placed before the board. Board will do nothing. Sit on it. And when it comes before the court,
My
board
lord,
will
it is, my
suddenly
lord,
think
now, my
that
lord, it
this
is
is a
established,
very
my
good
lord.
contention that this is fabricated.
My lord, in Bengali, there is a proverb, my lord, chorer mayer boro gala. Now it is, my lord, established.
Affidavit of service filed on behalf.
What happens in the selection
Cannot
process has been
record.
established before the Supreme Court this year itself.
এটা কি একটা রিপোর্ট দিয়েছে a report in the form of affidavit filed by West Bengal Board of Primary Education is taken on record by the present writ petition. The petitioner seeks direction upon the respondent authorities for consideration of her candidature for appointment as primary school teacher in West Bengal, and also for consideration of her representation dated 17 June 2025. Mr. Pranab Ghosh, learned advocate appearing for the petitioner, submits that in the earlier round of litigation in WPA 4923 of 2025, the board was directed to issue state certificate in favor of the petitioner. However, the same has not been complied as yet. He seeks for appropriate direction so that the order of the court is complied with and the petitioner is given appointment as a primary school teacher in West Bengal. On the contrary, Mr. Ratul Vishwas, learned advocate appearing for the WBBPE, submits that the Annexure P3 at page 24 of the writ petition is a forged and fabricated document. Page 24. In view of such assertion made in the report in the form of affidavit, the West Bengal Board, WBBPE, is directed to take necessary steps for causing investigation of such document which has been asserted to be fake and fabricated document, namely annexure P3 at page appearing at page 24 of the writ petition. And you file a inquiry report on the date fixed.
Your lordship, keep it pending, my lord. I will come back. My lord, directed,
And
my
file
lord,
a-
any, my lord, to lodge a
Please.
complaint and my lord, the
comprehensive report on the returnable date. Release this matter 3 weeks after the winter vacation.
my lord, report filed by the board or by lord, the
You
investigating
take
authority.
steps whatever is available to the board. If it is required that you file a FIR,
My lord, I got
causing
you.
inquiry or criminal proceedings,
I'll
or
come.
on your end, if any inquiry is required, you
Better, your lord.
take a
I'm grateful.
appropriate step and file a report accordingly what is the nature of this
Only
document.
humble submission
yes,
if the
great.
matter can retain its position, my lord. Only humble submission.
After 3
Yes,
weeks,
your
you still
lordship,
have
you will fix the date, your lord. Come back.
But
তিন
let it
সপ্তাহ পরে
retain its
date দিয়েছে।
3 সপ্তাহ পরে একটা ডেট দিয়ে দেবেন। দেখেন গেট বোর্ডে বল আজকে গেট এফআইআর গেট
Item 4,
আমাদের তুমি বলো আমি তো ব্রিফ নেই তো আমার তো ব্রিফ নেই না তুমি একটু বলো কি বোর্ড থেকে পাঠান লিখছি
now my lord, case has got a checkered career. I am not going to disturb your lordship by arguing at length and the history, all these things, but something is needed. এটা অ্যাপিটিউড সার্ভিসটা রাখো ভাই, সবাইকে সার্ভিস হয়েছে, আমি চেক করে নিয়েছি। Now my lord, this is actually a group of teachers, organizer teachers. My lord, they organized and in their own land, school was set up. So government thought that they must get some recognitions. Anyway, my lord, since there is inaction on the part of the government, then so many cases, ultimately matter went to the Supreme Court. I had a privilege to argue with the Supreme Court with Justice Dave and also Justice Kurian Joseph and Lokur. Anyway, my lord, I saw this order. Now, my lord, one order of Justice Lokur is very relevant. Before that, we order of Justice Dave. If your lordship can come to page 4 of that. If your lordship can come to page David. It's David order জায়গা।
এভিডেন্স সার্ভিস দিয়ে ফাইল করেছে দেখা
Page 51. There's a history, well, there are incidents. Actually, the day the case was fixed at 2 p.m. That was for delivery of judgment. Unfortunately, my lord, my client, a group of teachers, they couldn't intervene. So I appeared with an applications. So my lord, I want to say something. Today we are here to deliver the judgment. Mr. Raji, what are you talking about? And of course, you go and file an application. My lord, according to the Supreme Court rules, if the application is filed after 3 days, matter will appear. So by this time, judgment will deliver everything infructuous. Then he started smiling. All right, I'll hear you, no problem. Then he said, no, today will not deliver judgment. So which is at page 51, my lord. I appear, my lord, and then argued and kindly come to page 53. Page 53, my lord. Have you got it, my lord?
Yes.
Second paragraph. The said organizing teachers shall submit relevant document concerning their age and their qualifications to the verification committee within 4 weeks from today, and after verification thereof, in presence of the concerned organizing teachers, the verification committee shall come to final conclusions with regard to veracity of the certificates, and teachers shall recommend the name of the and certificate and the names of the qualifying organized teachers to the state within 4 weeks thereafter. Upon receipt of the said list, the state shall give appointment to the persons recommended by the verification committee within 4 weeks. Well, this is very, very relevant. So verification committee and then state, and once after verification, if it is found is other is all right, mandatory appointment should be given. Now, kindly take trouble to then come page. These are all Supreme Court judgment, my lord. 55 and 56. Another judgment of Justice Joseph and that judgment of Justice Dave. I had a privilege to point out and my application was accepted and order is passed. Page 55.
No, subsequent paragraph of 203 who were not there.
Yes.
This is also been submitted. The subsequent paragraph you read.
That is my client. My lord, that is why the court says, oh, Mr. Mani, you are not eligible. That's a very nice man. There's a doubt about it. My lord, very kind at judge. All right, I'm giving an opportunity. No problem.
Okay.
Then kindly, page 55, another Supreme Court judgment, my lord. Kindly take trouble to come. Page my lord, page 60,
67.
65.
page 60 first, my lord, 60.
Yeah.
Paragraph 6. The order dated such and such date as follows. We have heard the learned counsel for the parties at length. Upon hearing the concerned counsel and upon perusal of the relevant records and the orders passed by this court from time to time, we had passed the following orders on such and such date. In pursuance of the order dated 2nd December 1995, a verification committee has been verified the details with regard to 1257 organizing teachers and has come to its final conclusions that out of 1257203 organizing teachers who are parties in the petitions filed before the Calcutta High Court are below the age of 60 years as on today, and they are also qualified to become teachers as per rules which are just as then. The report of the verification committee constituted in terms of such, the report has been handed over to us in court such. The said organizer teachers shall submit relevant document concerning their organizer teacher, the age and their qualification to the verification committee with 4 weeks from today, and after verification thereof in presence of the concerned organizing teacher, the verification committee shall come to a final conclusions with regard to the veracity certificate, and teachers shall be given. Everywhere court says, first verification committee was formed by the Supreme Court itself. They say that, well, go and produce document. And once it is found and certified with the verification committee is all right, then there is no other but to give the appointment. Mandatory.
Yes.
My lord, kindly next, we direct that the 173 candidate, have you got it, my lord? As referred to in our order, it is such and such, passed in such and such, in such and such and such, shall be appointed as primary teachers with effect from such and such, and their appointment letters shall be given to them before 31st October 1926. Now, my lord, nothing was done. Then contempt application was filed before Justice Korean Joseph. Mr. Mani Bhattacharya and Mr. This or something like that. Imam, he was the secretary of the government. He said, I am not fault, I am not fault. Whatever I have done, is of Mr. Bhattacharya. Then said, there is no scope. Mr. Korean Joseph from open court. Yes, look, if you do not come with the appointment letter, I'll show you what is what. Don't have to play with the court. Now we know what is actually happened subsequently, and Mr. Bhattacharya and others. Then, kindly trouble to come, page 65. Paragraph 8. Last few lines. It starts with direct the secretary.
Yes.
We direct the secretary to the West Bengal State Legal Services Authority to verify the remaining grievances of the appellant herein and the interveners and such and such and such. It will be open to him to adopt any method for the verification. And this is ordered by Justice Joseph.
Why it has been now
My lord?
sent to the West Bengal?
My lord?
Why it has been sent to West Bengal State Legal Services to verify when
Because
there is a committee?
the honorable judges lost their confidence on all those people.
So verification committee was of the state.
Yes, verification committee appointed, that is the Supreme Court directions.
Verification committee was consisting of members who were appointed with the state authority. From the state authority, the verification panel was.
State legal authority. State legal authority.
No, my
Legal-
query is, since there was already a committee, now it shifts to the state legal services only because there was a miscommunication with the committee not functioning properly or
That's-
something of that.
That's absolutely correct. That is why. and disgusted Supreme Court. What is going on over there?
Read the paragraph 9, my lord, the entirety. Paragraph 9's
No,
entirety.
no, he is placing that.
No.
এটা ঠিক করে বসতো? Like an entirety. Then, my lord, nothing was done. And we expected the appointment should be given. By this time, unfortunately, overaged. Under similar circumstances, the Calcutta High Court was approached. My lord, I brought the judgment, my lord, which is very relevant. Similar circumstances. So very well, they are not entitled to have the job, but you must compensate them. They are eligible for the appointment. They are eligible to be appointed as a teacher to perform the duties. They are eligible to have the money, compensation in terms of money, because you, the people, you are responsible. You have not done so. Can you take trouble this judgment? The division bench judgment, which is reported in 2025 to CHN. Are jealous koi jisko na?
পেজ কত?
বলছি ব্যস্ত হোস না।
পেজটা কত?
এই নাও ভাই, দাও জাজমেন্টটা। কবি দেবে কেন?
না, পেজটা কত বলো? তাহলে তো পাতাটা বলো।
2025 to CHN, Calcutta High Court notes.
হ্যাঁ, পাতা
663. Judgment of Justice Horis Tandon, Sri Justice Sampad Dotto Pal. And no appeal was prevailed before the Supreme Court against the judgment. It's a very tiny judgment, as it is not already done by Justice Tandon. So, my lord.
পড়েছিলাম এটা।
Wait.
এই হয়ে করিস না।
কোন না সুপ্রিয় ছিল?
কিন্তু চক্র। So, my lord, in this judgment, their lordship says, we'll have to do that. Now, can you take trouble? I will also got the judgment.
Yes.
নোট ডিভিশন ওটাতে ছিল ওটা।
ঠিক জাজমেন্ট দিয়েছে তো?
Paragraph 12 is very relevant. The drastic remarks. With your lordship, kindly leave, may I place this paragraph 12?
Yes.
No civil society. Of course, we have got doubt whether still you are in the civil society or not, as a whole. But anyway, anxiety. No civil society would permit an executive to play with the fate of the people of this country and claim that they can act as a sovereign as they are bound to act within the circumstances of the states, of the statute, and the constitutions and their respective responsibilities enshrined therein. It is a hard reality that the country is grappling with a large section of people who are unemployed, though the efforts and attempts are being made to generate the employment with the good object of providing livelihood, being one of the fields of the fundamental rights inside another part of the Constitution. It is no longer res integra, but the right to life under Article 21. And now Article 21 is very widely. When we joined, my lord, we did not get this opportunity because nobody is conscious about that. Subsequently, my lord, we found the Sonar Khoni, Article 21 in the constitutions. The employment is necessary. Encompasses the right to livelihood, and therefore any deprivation is construed as an infringement of such fundamental right, and the court cannot remain a mute spectator. It is a fundamental duty of the court to reach to the justice to be imparted to the people whenever it is found that the same is being violated. We do not find any failure on the part of the court in awarding the compensation by holding the relief, taking into account the change in the circumstances of the subsequent event happens in course of the judicial proceeding. The power to mold the relief is ingrained into the system, and therefore we do not find any writ court has exceeded its jurisdictions in awarding the compensation after having made award that the appointment was made in the petition institutions. A plea is sought to be taken by appearing defendant that at the time of issue of the assessment, the claim of compensation doesn't. Ultimately, my lord, the compensation was given. And my case is better than that. The committee, up to Supreme Court, we got the order. In one case, Justice Joseph, my lord, he was rather in compelling circumstances. 62, because I appeared, I know that, but 62 persons, teachers, Orient teachers. He says, bring the appointment letter, hand it over to Mr. Banerjee. I said, no, I will not take the responsibility. Concern. And directed 62 candidate got the job. Well, enough is enough. You are unnecessarily depriving citizens. If they are disqualified, no problem, do that. But when it is found, a committee that well, is otherwise eligible, and the mandate of the Supreme Court, once it is found, there is no authority but to give them an appointment. So here, my lord, that has not been done. So I am entitled to have the compensations for the negligence and other things. Law doesn't mean to be mere theoretical abstraction. It is an instrument to do the justice. I am here to have the justice. My lord, justice for these reasons. We have set up the school. We on our land. We constructed the school. We did everything. We spent our golden time and years for the development of the education of the state. And unfortunately, we have been deprived of anything. And so many things have been happening in the
In your
meantime.
case, the verification report has been given. Verification report in respect that, yes, he qualifies.
Yes, they are not disputing anything. I could have understood, no. Verification is there, fell. I'm fail.
All the petitioners have
Of course.
crossed 60.
Yes, they have already crossed 60. So naturally, they cannot get any employment. Paragraph 31 kindly come, my lord. 31, 30, 33. Up to that level, my lord, under the source of the Supreme Court, everything is all right. Paragraph 31. Have you got it, my lord? Paragraph 31. That in terms of the Honorable Supreme Court order passed on 21st January 2020, your petitioners were given inspection of the said verification report in the office of the Secretary of West Bengal Legal Service Authority. Supreme Court is constantly given that. Then it transferred from the said verification report out of 703 candidates, 58 candidates petitioned for Hooghly district branch and were given appointment, having cited the remaining, leaving aside the remaining 645 candidates without giving any appointment.
They are part of the 645.
Of course. It is submitted that as per the said verification report, out of their remaining 645 candidates, 140 candidates were reported to be overaged, whereas candidates below 60 years, but all those candidates as assistant teacher in as much as.
Okay.
So we have lost it. We didn't get any opportunity. But the very unfortunate thing is this, when it's part of the Supreme Court order, and Supreme Court observe, I cannot observe, directed verification committee, if it is found they are competent, appointment should be given by the state.
Okay.
If the appointment is not given, then you must compensate. And that is the judgment of Justice Tandon.
Okay. Let us hear the state.
My lord, though my lord, I have not served the copy of the writ petition, my lord, I am thankful my learned friend, my lord, appearing for the state, my lord, handed over a copy to me. My lord,
No, this is not correct. Mr. Vishwas, please inquire from a department. From affidavit service there, then my client will suffer like anything. Everything was given. This is my livelihood.
yes, yes.
My lord, your lordship, my lord, this is a, my lord, the organizer teachers of 1993. My lord, is a checkered history, my lord. It is not the, my lord, the one order or two orders. But there are so many orders. My lord, it started from on and from, my lord, 1993, organizer teacher. My lord, at
Sorry
that
to
point
interrupt,
of
my
time,
lord. When I started argument, probably he was in a school or college student. Sutarang, I know everything. How many days?
I'm grateful, my lord. That is why, my lord, my learned senior friend, my lord, we are, my lord, every day learning from them, my lord. My lord, 1993, my lord, there was a concept, my lord, when the, my lord, there was no, my lord, the direct recruitment, there was an organizer teacher concept. Your lordship knows, my lord. And from 1993, my lord, it continues. My lord, 2000, my lord, my lord, the writ petition was filed. Thereafter, my lord, the division bench, thereafter SLP. My lord, ultimately, what my learned senior friend, my lord, has relied upon the, my lord, the order. My lord, this is probably the last order. Thereafter, also 1-2 orders are there, my lord. Just, my lord, your lordship, my lord, even after this order, my lord, there are so many writ petitions filed before this honorable court, asking the similar prayer, dismissed. My lord, today, my lord, I am not, my lord, equipped with that order. My lord, I will come. But before that, your lordship kindly come to page 60 of the writ petition. My lord, page 60. My lord, before that, my lord, your lordship kindly, before that, just, my lord, to assist your lordship, my lord, page 56. My lord, because every, my lord, the paragraph is vital. Page 56, starts from page 56.
See,
Yes.
what he has asserted his right is that as per the verification report.
My lord, no. I'm just coming. I got your
Just a
lordship.
minute, let me clarify.
My lord.
As per the verification report, they were supposed to be given appointment as per the order of the Honorable Supreme Court. That has not been given. Now they have crossed 60 years. They cannot be given appointment. They seek for compensation.
My lord,
Now, if you refute to that, come up with such a report that they are not entitled to that. File a report, a
Before that,
comprehensive report to that.
my lord,
We
I'm
will
just,
hear on that. Give a copy to
my
them.
lord, I'm just coming, my lord. My lord, I'll show, my lord, prima facie. My lord, there is no scope of any interim order. But prima facie, my lord, I'll show, my lord, that even this writ petition is not also maintainable. My lord, your lordship kindly come to, my lord, just I'm skipping all the paragraphs. Your lordship kindly come to page 66.
Paragraph 9.
Page 66. My lord, no court shall entertain any further challenge on the report that submitted by the secretary to the West Bengal Legal Service Authority, and there shall be no further dispute in this regard. My lord, in this regard, my lord, means, my lord, that is why, my lord, I wanted to show, my lord, from paragraph 1 to, my lord, till, my lord, paragraph 9. My lord, not entertain any phrase application or phrase record. We direct the registry of this court to forward this record as on 25th April 2028 to the secretary to the West Bengal Legal Service Authority, wherein the 10 days from today, my lord, everything was done on the monitoring of the Supreme Court. Now my learned friend cannot come before your lordship and, my lord, ask any prayer in respect of this, my lord, because, my lord, why I, my lord, shown your lordship in the paragraph 6 of the, my lord, the order of the Supreme Court, my lord, paragraph 6 of the Supreme Court order, your lordship will find, my lord, page 60. My lord, your lordship will find the figure 1257 number 1257. My lord, in the erstwhile order in the Supreme Court, it was mentioned that those who were the member of the organizer teacher of 1257 member, and, my lord, there are, my lord, another, my lord, the condition, and, my lord, who filed the writ petition before this honorable court prior to a cut-off date, my lord, given, my lord, in this order. But that two condition has to be fulfilled by the any of the applicant. My lord, there are so many, my lord, I personally, my learned friend, my lord, this matter, my lord, from the day one. But I also, my lord, for last 20 years, my lord, from the day of my profession, my lord, I have also, my lord, doing this matter. But I personally, my lord, obtained the certified copy of those writ petition where 1257 were party to that. My lord, at that point of time, my lord, it was a, my lord.
So what you are proposing to do, you will file an affidavit in opposition to the writ petition or a
My lord,
suffice?
after the paragraph 9, my lord, I
No,
am
paragraph
asking
10.
myself,
Paragraph 10.
my lord,
Nine.
paragraph 10 of
No,
page
no.
66.
Nobody is challenging the report of the Secretary of West Bengal Legal Services Authority. Court says that there should not be any challenge to the report.
My lord,
They say
not the report.
that
Dispute.
in para 31 of their writ petition, they say that as per the report of the verification committee, they should have been given an appointment,
That's all.
which has not been given. Now you confront whether their name appear figured, whether they are actually to be given an appointment prior to reaching their age of superannuation. This has to be brought on record. If you say, again, with you I am reading,
My lord,
paragraph 10 at
My
page
lord.
60. 66.
My lord,
No court shall entertain
Hmm.
any further challenge on the report because the Honorable Supreme Court
I
from
got it,
the
Lordship.
verification committee, it has shifted to now to the Secretary West Bengal Legal Services
Authority.
and made it clear that the report that will be submitted with regard to verification of the candidates, that will be final. And no court shall entertain any
Any
such
of-
challenge to the report.
I'm grateful, my lord.
Now, he is not challenging the report.
One thing, my lord.
My lord,
Why that? Why?
my lord,
One thing.
thereafter,
Why-
my lord,
No,
my
no,
lord,
he will be
thereafter.
coming up with the report or that's why I'm
There shall
asking
be
you.
No, my lord,
no
one thing,
further
one thing, my
dispute.
lord. 5,400.
But I am also, my lord, harping. There shall be no further dispute. My
What
lord,
is the
next line.
dispute?
Yes.
My lord, dispute is that, my lord, because the committee has not given them appointment after verification, everything, my lord, is their averment in
It
the
is
writ
not the
petition?
committee who will give the appointment. Mr. Vishwas, what are you talking about? Committee will say that, well, they are eligible.
Dispute in this regard.
Please go to this judgment. Once it is,
I think that is with regard to the report of the secretary.
yes, but because so many
Any
persons.
event, my lord, what
But you
if
file your affidavit of opposition. Containing the maintainability point, we will also decide on this aspect also.
my lord, your lordship keep the maintainability point.
And also you say that some of the writ petitions will be dismissed.
My lord,
Whether this
I'll-
petitioner and those petitioners are similarly circumstanced or not, that is also to be seen.
No, similar point. The similar point it was
Let us
decided.
see.
my lord, I will, my lord.
Mr. Rasul, affidavit of service filed on behalf of the petitioner is taken on record. Mr. Ashok Kumar Banerjee, learned senior advocate appearing for the petitioner, submits that the petitioners are the
Organizer teacher কিছু নেই।
West Bengal organizer primary teachers
Okay, affidavit of service
who,
কবে পেয়েছে আমি দেখি board
as per the order of the Honorable Supreme Court, passed in civil leave to appeal C number 15253 of 2006 upon verification by the verification committee was supposed to be given appointment. However, with the passage of time, such appointment has not been given by the respondent authorities to the petitioners. All the petitioners have crossed the age of superannuation, that is 60 years. The petitioners before this court prays for compensation. In support of his contention, he relies on the decision of this court passed in DPS Bardhaman versus Abhishek Madunai, reported in 2025, Volume 2, CHN Cal 663. On the contrary, Mr. Ratul Biswas, learned advocate, appearing on behalf of the West Bengal Board of Primary Education, submits that in the similar circumstances, the writ petitions have been dismissed by this court. He also indicates that the writ petition is not maintainable in view of the observation of the Honorable Supreme Court in the 66 is the continuation of which order?
My lord, at page, my lord, 55, 56,
Paragraph
55.
10,
55.
55. Para 10 of the judgment of the Honorable Supreme Court passed in Civil Appeal 4773 of 2018 along with other appeals. He seeks to file an affidavit in opposition to the writ petition. Let such affidavit in opposition be filed.
What date,
Sir.
my
Mr. Biswas,
My lord, at least 6 weeks, your lordship, my lord. The whole record I have to, my lord.
What is 6 weeks? He knows every fact.
within a period of
আপনি তো মাত্র 20 বছর আমি তো
weeks,
প্রথম দিন থেকে করছি
হ্যাঁ?
93 থেকে মানে সব ফ্যাক্ট
after
কেন তুই কেন
8 weeks,
তার আগে 20
uh,
বছরই যা
after
করেছিস
vacation,
আমি 220-তেও করতে পারবো না।
2 weeks to file reply. Release this matter
স্যার আপনাদের আশীর্বাদ
after 5
Well,
weeks
4 weeks
under the heading motion থেকে miscellaneous এ দিয়ে দাও, হ্যাঁ, February 1st week এ 3 weeks and
no, my lord, do not put it on the list. Only date, fix the dates, otherwise it will never be heard. Not
3 weeks for him to file the affidavit in opposition, 2 weeks for you to file the reply. 5 weeks পরে একটা উনি বলে একটা ডেট দাও। হিয়ারিং এর এখানে 6th February.
Lordship.
You were appearing for whom?
I'm for the DPSC Hooghly, Lordship.
You will be filing in opposition.
No, this will cover, if required, I shall file a report,
No, no,
short
no,
report may be filed, my lord. If required, my lord, I let me talk with
If
them. my lord.
required, then over 6th February again the date has to be
No, no, my
fixed.
lord.
Yes.
What is happened, my lord?
Uh.
What is happened, my lord? Their entire
Kindly record it, my lord.
my lord,
Kindly
act
record it.
from this document, my lord, I find, my lord, their entire grievances against the State Legal Service Authority, although the State Legal Service is not the party in this matter,
Will come, my lord.
not
That chapter
party.
is closed. Kindly
and
record it,
lord-
my lord. They don't like to use the affidavit.
No, no, my lord,
Otherwise, again, there will be some
that is, my
problem.
lord,
For the
if
points has been raised, my lord. we
that
are
is our
concerned,
point.
Don't require.
Yes,
If so, new point.
Mr. Banerjee, State Legal Services Authority has to be made a party.
Yes,
So the report is concerned, that
They
is.
grant
the
you
because
reason.
their report is there, my lord. Supreme Court has constantly
They have
said,
the direction to file a report. They have given the report. They know that. So their presence is unneeded. Their chapter is closed.
Okay.
Their chapter is
No,
closed.
they
Report
are,
is lying before the state.
Let
legal
it come up on
service
6th. We'll see.
Lordship.
You file your affidavit in opposition thereafter.
But actually, why Supreme Court passed this order? Maninder Singh, subsequently he became the additional solicitor general. He came with a petition of 5,400 persons. Their lords became fed up. What you are doing, Mr. Singh? Henceforth, no more, I will not allow anybody. Regarding the main, as it is pointed out by lords, regarding that aspect.
Okay.
May I leave, my lord?
Yes, thank you, sir.
hey, 1, 2, 3 হবে না? Oh,
My lord, item 5, my lord, I am for the petitioner. My lord, this matter relates to all.
That was
My lord, all the petitioners are.
yesterday you mentioned this matter.
Yes, ma'am. Date 2014, 23, 25 session. My lord, similar order. My lord, your
Easy.
lordship can follow this.
ও এটা ওই মামলা
My lord, here everybody is, this is a mixture of petition of 22, 2014. So your lordship,
This is a petition for 14 only.
this is a petition for only 14.
14.
এই আগের দিনে 4টা দিন বললে দিলি না তো
And also 23, 25 date.
Yes.
Yeah,
no,
23, 25 DLAD.
Yes.
Acha. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for publication of final results of diploma in elementary education in short DLED for the session 23-25 prior to the last date of application of recruitment notification, and also for
এই
directing
ব্যাপারটাকে দিয়ে দেন
the
অর্ডারটা
respondent numbers 2, 3 and 4 to accept the application of the petitioner for selection process in connection with the said recruitment notification. In the present writ petition, the petitioners are all qualified in TET 14, untrained. Untrained. Dismiss will pass the order.
My lord, yesterday, my lord, your lordship remember 2 similar matters. My lord, as per your lordship direction, I have handed over that.
I have got the list. Thank you.
আমার একটা কপি দিস
এটা সিমিলার হবে, আমি একটু কারেকশন করে দেবো এটা, হ্যাঁ? দেবী হবে। শুধু ওই কিছু কিছু জায়গায় মিস্টার চতুর্বেদীর সাবমিশন আছে, ওটা বাদ দিয়ে দাও। চেম্বারে আসবেন, কালকে 2টো আছে, সুনীত বাবু ছিল, আর ওই এটা দিয়ে দাও। বলে ওকে বলো এটা দিতে, অ্যাপিয়ারেন্সটা দিয়ে দিতে।
Item 7.
7, I'm for the petitioner, my lord. Before vacation, I will not trouble your lordship. But this matter has to be decided on affidavits. There is no scope of passing any interim order. But there's an application that we have filed for addition of party. But before it, my lord, they have to file their opposition if they wish to.
Has it been served?
Yes, we have served it, my lord, our
My
affidavit
lord,
service.
My lord, before we proceed, my lord, I have a point of maintainability, my lord, because according to me, this writ petition is not maintainable, my lord.
What is the CAN application for?
My lord, we have filed an application with addition of parties. My lord, since my learned friend is saying that they have not been served.
My lord,
may
I appear
comment
for the
after
writ.
vacation, my lord. In the meantime, we shall exchange the documents.
My lord, I have no issues with that, my lord, but my lord, may the
maintainability-
point on
It should be
maintainability
served.
be heard.
You give a copy to
Yes, yes, definitely, I'll come.
My lord, may the point of maintainability, because it will be dismissed in limine, my lord. It's not maintainable at all.
They can take it in their opposition.
My lord, I would
Okay, what
like
did you
to press my point of maintainability before. My lord, now this is a writ petition that's been filed.
Submit what is the writ petition all about.
Very well.
The writ petitioner was a teacher in under Ramakrishna Mission. He was working there for nearly about more than 7 years. Suddenly, my lord, the respondents issue a notice that you need to have the B.Ed degree, then only we'll allow you to continue. Now, my lord, in that circumstances, we write to them that there are other teachers who are equally qualified as that of me. Then why are they being allowed to continue and I being subjected to termination on that sort? Now, we challenge the writ petition. Thereafter, my lord, we have filed an application, including, my lord, we have sought for addition of party of all the teachers who are having the same qualification that of me, and they have not been issued any notice that you need to have B.Ed qualification or not. Only me.
May I, my lord?
Now, my lord, the only point that can be raised is contractual employment subject to writ petition.
Hmm.
Now, my lord, in view of the observation in Jagdip Singh, my lord, by the Honorable Supreme Court, where, my lord, it has been categorically stated that if there is a disparity or any infringement or any of the, but if I may say that biasness towards one, then I cannot be left remediless. If there is an infringement to right to life, my lord, I can always come before your lordship.
Okay. How many
There-
are there?
What?
How many teachers are there?
But there are, I believe, 17.
Now, you have been removed from your service.
Yes, on the
One,
ground
two,
that
four,
you need to have
5.
B.Ed degrees. Your lordship kindly takes up page 21. Now, Lord, pursuant to the order of this court, my lord, this honorable court had directed us to amicably settle the issue with the authorities. Now, we take an endeavor to settle it. But, my lord, unless and until there is a order of this court for reconsideration or not, my lord, I do not think the authorities will act on it. Therefore, my lord, I sought at the very outset that let them come back with affidavits and, my lord, fixes for hearing, my lord, we shall argue on that.
Okay.
My lord, may I?
No. Not now. What is the service upon the Ramakrishna Mission?
My lord, we have served them.
My lord,
Service time.
I have not received the can, my lord.
We'll give you.
I have the writ petition. I appear for Ramakrishna Mission, my lord.
You are appearing from Ramakrishna.
I appear for Ramakrishna Mission, my lord.
Do you appear on the last occasion?
Yeah.
Sorry, please. Yes,
Yes.
we have served you.
Yes, Singh.
No, actually, sir, I'm served on. She's just AOR. I'm not the AOR.
On 17th of February 2025, my lord.
Received it, yes, Kunji. I don't know.
Give a copy to
There's
him.
some other.
We'll come back, my lord.
My lord,
Stop
but
them.
my lord, allow me to,
Serve
my
again,
lord,
we'll come.
allow me to press my point of maintainability before this, my lord. My lord, the first point I'm going to take is, my lord, a writ petition against Ramakrishna Mission in particular relating to contractual disputes, it's been settled by the Supreme Court, my lord, is not maintainable. And my lord, the second point I'm going to take is, my lord, the degree that's necessary is DEIES diploma for the particular course, right? For them, for the petitioner to teach the particular course, my lord, and it's mandatory. Now, my lord, that degree, whether now if the petitioner chooses not to pursue that degree, my lord, that degree is not amenable under judicial review, my lord, because it is the state's function. My lord, allow me to place two judgments for these two propositions, my lord, and it'll be quite clear that this writ petition is not maintainable. We don't have to, my lord, go into the can. My lord, the first judgment I'll place is
Mr. Basu Murli.
Actually, my lord, at that point of time, my lord, since I appearing for the state, my lord, I couldn't appear. That's what.
You're not responding. Your name is appearing here. You also asked the similar point before the court.
I am for the state, I believe.
Yes, for the state.
Yes, now, my lord,
Now this maintainability point was raised. Justice
Yes.
Basu has directed to have it kept open for the disposal of this petition time. It will be taken up.
now, my lord, now since my lord, I am no more in the panel. That's
So who is appearing for the state?
he is appearing.
You are for the state. Okay. Yes.
That judgment is there.
My lord, may I hand over?
That has clearly indicate, my lord.
Give that.
My lord, I rely on 2019-16 SCC 303. My lord, kindly, so my lord, this was a writ petition filed against a hospital run by Ramakrishna Mission, my lord. Now, my lord, kindly come to para 23, my lord.
Yes.
In VST Industries versus Workers Union, a two-judge bench of this court has held that a mere violation of the conditions of service will not provide a valid basis for the exercise of the writ jurisdiction under Article 226 in a situation where the activity does not have the features of a public duty. This court noted, my lord, so-and-so, the quoted portion, my lord, now subpara 1, my lord, 23 subpara 1, the test of whether a body is performing a public function and is hence amenable to judicial review may not depend upon the source of its power or whether the body is ostensibly a public or a private body. The principles of judicial review prima facie govern the activities of bodies performing public functions. In the following two situations of judicial review will not normally be appropriate, even though a body may be performing a public function. Where some other branch of the law more appropriately governs the dispute between the parties, in such a case, that branch of law and its remedies should and normally will be applied. And where there is a contract between the litigants, in such a case, the express or implied terms of the agreement should normally govern the matter. This reflects the normal approach of English law, namely that the terms of a contract will normally govern the transaction or other relationships between the parties rather than in general law. Thus, where a special method of resolving disputes such as arbitration so-and-so, that regime and not judicial review will normally govern the dispute. Para 24, my lord. In G. Bassi Reddy versus International Crops Research Institute, a two-judge bench of this court dealt with whether International Crops so-and-so, which is a non-profit research and training center, is amenable to jurisdiction under 226. The dispute concerned the termination of employees of so-and-so. The court held that only functions which are similar or closely related to those that are performed by the state in its sovereign capacity qualify as public functions or public duty. Now, then 4 lines. Although it is not easy to define what a public function or public duty is, it can reasonably be said that such functions are similar to or closely related to those performable by the state in its sovereign capacity. The primary activity of so-and-so is to conduct research and training programs in the sphere of agriculture purely on a voluntary basis. A service voluntarily undertaken cannot be said to be a public duty. Besides, so-and-so has a role which extends beyond the territorial boundaries of India, and its activities are designed to benefit people from all over the world. While the Indian public may be beneficiary of the activities of the institute, it certainly cannot be said that ICRISAT owes a duty to Indian public to provide research and training facilities. Now, my lord, para 28. However, the scope of mandamus is limited to enforcement of public duty. The scope of mandamus is determined by the nature of the duty to be enforced rather than the identity of the authority against whom it is sought. If the private body is discharging a public function and the denial of any right is in connection with public duty imposed of such body, the public law remedy can be enforced. The duty cast on the public body may be either statutory or otherwise, and the source of such power is immaterial, but nevertheless, there must be a public law element in such action. There cannot be any general definition of public authority or public ownership. The facts of each case may... Now, my lord, para 29, placitum B, my lord. However, we may add that even in such cases, writ would not lie to enforce private law rights. There are cantina of judgments of this aspect, and it is not necessary to refer to those judgments, as that is the basic principle of judicial review of an action under the administrative law. The reason is obvious. A private law is that part of a legal system which is part of common law that involves relationships between individuals, such as law of contract or torts. Therefore, even if the writ petition should be maintainable against an authority which is state under Article 12 of the Constitution, before issuing any writ, particularly writ of mandamus, the court has to satisfy that the action of such an authority which is challenged in the public domain of public law is distinguished from public law. Thus, even if the body discharges a public function in the wider sense, there is no public law element involved in the enforcement of a private contract of service. Having analyzed the circumstances which were relied upon by the state of Arunachal Pradesh, we are of the view that in running the hospital, Ramakrishna Mission does not discharge a public function. Undoubtedly, the hospital is in receipt of some element of grant. The grants which are received by the hospital cover only a part of the expenditure. The terms of the grant do not indicate any form of governmental control in the management or day-to-day functioning of the hospital. The nature of the work which is rendered by Ramakrishna Mission in general, including in relation to its activities concerning the hospital, is purely voluntary. Before an organization can be held to discharge a public function, the function must be of a character that is closely related to functions which are performed by the state in its sovereign capacity. There is nothing on record to indicate that the hospital performs functions which are akin to those solely performed by state authorities. Medical services are provided by private as well as state entities. The character of the organization as a public authority is dependent on the circumstances of the case. In setting up the hospital, there is nothing on the medical services are provided by private as well as state entities. The character of the organization as a public authority is dependent on the circumstances of the case. In setting up a hospital, the mission cannot be construed as having assumed a public function. The hospital has no monopoly status conferred mandated by law. That it was the first in the state to provide service of a particular dispensation does not make it an authority within the meaning of Article 226. State governments provide concessional terms to a variety of organizations in order to attract them to set up establishments within the territorial jurisdiction of the state. The state may encourage them as an adjunct of its social policy or the imperatives of economic development. The mere fact that the land has been provided on a concessional basis to the hospital would not by itself result in the conclusion that the hospital performs a public function. In the present case, the absence of state control in the management of the hospital has a significant bearing on our coming to the conclusion that the hospital does not come within the ambit of a public authority. So, my lord, in the instant case, Ramakrishna Mission is running a university.
Yes.
My lord, in the instant case, the Ramakrishna Mission is running a university. My lord, what they are challenging is a particular condition of service. We do not have a monopoly in terms of running the university. We may have a grant by the state government, but absolutely similar situations, my lord. We cannot be amenable to a writ jurisdiction, my lord. That's my first point. And my lord, my second point.
So how these teachers are being appointed in Ramakrishna Mission? How the teachers are appointed in Ramakrishna Mission? What is the criteria?
My lord, there are state service rules, one, and there are rules by Ramakrishna Mission, my lord. Both of those rules govern it, my lord.
What is the procedure of appointing a teacher? What rules are being followed?
My lord, there are state service commissioner rules. For example, my lord, kindly have a look at this letter, my lord. That will make it more clear, my lord. Kindly have a look at the letter dated 16th May 2024, my lord, page 21. There are certain qualifications that are required. Those qualifications are set by Ramakrishna Mission in tandem with the state government, my lord. Now, my lord, in this case, the qualification required was DEID diploma. So, my lord, just kindly have a look at
Where
this
is the
letter.
appointment letter?
My lord, the appointment letter, my lord, I need to take instructions, my lord, because I do not have the appointment letter as of date, my lord. So, my lord, I do not have the appointment letter with me right now, and they've not annexed it to the petition.
Because factually also we have to see under what rules they have been given appointment. See, in the letter also it says that you have to have a DLED diploma course, your requisite qualification, which is in consonance with the notification of the state government.
Right.
Whether this panel is prepared keeping in light the notification of the state, whether the state prepares the panel and it is sent to the Ramakrishna Mission, which again takes an interview. On being satisfied, they prepare a fresh panel. Whether it is a contractual service, what are the conditions of service that was entered into? Then, in the light of the decision of the Honorable Supreme Court, will assess all these facts.
Very well, my lord. Then kindly press my second point then. Because my second point, we don't need any of...
You come up with an affidavit in opposition to
Lord,
the
kindly give me just one minute, my lord, of your lordship's time, because my second point does not need any of this information. My lord, it is not in dispute. The petitioner has not disputed that this course requires the DEID diploma. So, my lord, this is an absolute point, right, my lord? And this is also not in dispute that the petitioner has refused training, my lord. That is very evident from the letters pursuant to that, my lord. So, my lord, in that respect, when these two facts are not in dispute, my lord, the particular qualification, whether it's required for this post or not, cannot be amenable under judicial review, my lord. In that respect, my lord, this writ petition has to go, my lord, because they are not disputing that we should not require this qualification for this particular post, my lord. In that respect, kindly let me place two documents on record and, my lord, one more judgment.
Well, let them come up with an affidavit.
What is your difficulty? I'm
No,
asking
my
you to
lord,
file an affidavit.
very well, my lord. I'll file an
affidavit. You say that what was the terms of the appointment given.
Very well, my lord. Kindly then keep the point of maintainability
You
open.
say that this qualification was required. He is not holding that qualification. If that be so, whether at the time of appointment this was there, it needs to be. You go
Very well, my lord.
and then find out.
We'll file an
I said it, but let
It
them
will
come
be
with
easy
an
for
affidavit.
all of us to assess the fact.
But one thing I just indicate, since this lordship was headed with Ramakrishna Mission, my lord, enjoys my lord autonomous status. From 2012, my lord, they are enjoyed autonomous status.
Okay.
So that should have been, my lord, pointed out to his lordship, my lord. He just pointed out to his lordship, my lord. They have
Keep
enjoyed
the
autonomous
mentality point
status
open.
from 2012.
But regarding the appointment that is given,
Everything, my lord, everything. Let him come up with all this, my lord, because everything has been explained in that, my lord, notification, which has been given to Ramakrishna Mission for their, my lord, this autonomous status. So how the teachers will be engaged and how everything has been classified there.
you place that also.
Very well, my
But
lord.
keeps the mentality point open, my lord.
Mr. Regarding CAN application, you give a copy of the CAN
Yes,
application.
My lord, I have not been served, so
State has been served with the CAN application.
Well, we'll do it today.
please serve it to my
Yes.
AOR. Not to me, to my AOR, please.
Learned advocate for the petitioner undertakes to serve
I'll
copy of the CAN application upon learned advocate for respond numbers
Lord, 2, 3, 4, and 5, my lord.
3, 4, and 5. At the outset, Mr. Swain learned advocate representing respondent 3, 4, and 5, Ramakrishna Mission, submits that since the paragraph is not discharged, is a private body, since Ramakrishna Mission is a private body, not discharging any public function / public duty, save and except receiving certain grants from the state. The writ petition is not maintainable against such organization under Article 226 of the Constitution of India. He relies on the decision of, to buttress his contention, he relies on the decision of Honorable Supreme Court passed in Ramakrishna Mission and another versus Kago, Kunya and others was reported in 2019, volume 16, SCC 303. He seeks to file affidavit in opposition to the writ petition and also submits for keeping the point of maintainability open, full stop. In view of such submissions, respondent number 3, 4 and 5 is directed to file their affidavit in opposition to the writ petition. The point of maintainability is kept open and maintainability of the writ petition is kept open and shall be decided at the final disposal of the writ petition. You also place all your documents.
I'll do that, my lord.
Limited to file reply to that.
Out of Korodin, 2 weeks and
My lord, may I get 3 weeks after vacation, my lord?
3 weeks after ensuing vacation, 1 week for filing reply. First week February, first week.
But at 2 p.m. kindly fix it up, we'll complete it.
Not 2 p.m. It is February date, February first week.
My lord, any day other than 6th, my lord, 6th February. Any day other than 6th February, my lord.
It is miscellaneous আসছে তাহলে কবে ফ্রাইডে দিন 13th February.
Very well, my lord, grateful.
Grateful.
কি আছে
কি করেছো
আমাকে একটা কফি দেবে তো my lord on the
file exception to the report filed by the
a copy be served upon me, my lord.
the copy I am handing over copy.
My lord, let a date be fixed, my lord. Just now copy is served, my lord, upon me.
Revocation of suspension order pending disposal of the criminal proceedings. My lord, criminal proceedings is pending. Complaint lodged by the midday meal worker levy. Alleged comments was committed outside of the school premises. No disciplinary proceedings has yet been initiated by the GPSC Posting Medinipur. My respectful submission, kindly revoke the suspension order pending disposal of the criminal trial. Nothing more. I am relying some judgment of the Supreme Court as well as my lord of this honorable court. Fair on the point. Proposition is that, my lord, no delinquent officer should be put on the suspension for indefinite period.
When was the suspension order issued?
Look page number 45 of the my lord.
Just now the copy of the exception is, my lord, served upon me. Kindly fix a date, my lord. On the next day, my lord, the matter will be heard.
Who filed the report?
My lord, initially I filed the report. Today he has filed the exception to my report. And a copy is being served upon me, my lord, just now in court.
I has been put on the suspension.
And my lord, no notice, nothing. Therefore, my lord, I have, without brief, my lord, I have come. Kindly allow me some time because of that for going through it. And my lord, let this matter be taken up any day.
When was the suspension order issued?
My lord,
19th September 2020.
19th September 2023, my lord, page number 45, running page number 45 of my writ petition. And my lord, since 1st August 2023, I have been put on suspension. Sunil Kumar Mandi, teacher in charge of Ambiguria Primary School under Madhpur Circle, who is involved in Kharagpur PS local case number so and so, dated 31st July 2023 under section 376. Allegation under section my lord 376, 417 and 506 of IPC is hereby placed under suspension from 1st August 2023 from his post as he detained in custody beyond 48 hours as per Rule 7, Rule 2 of the West Bengal primary education, conduct of service of teachers of primary school rules 2001. No disciplinary proceedings has yet been initiated by the appointing authority. I have been put on suspension. Suspension allowance has been
Yes.
The allegation is very serious.
Exception to the report of the state.
কি করবো? Political না না ঠিক আছে ওকে ওকে নেক্সট যেতে করে দাও আরে একটা আমাদেরকে একটা নোটিশ পুলিশ তো দেবে আরে ধরে বাবা ওইটা বলছি না এই যে মামলাটা আজকে আসবে একটা নোটিশ দেবে তো তাই তো ব্রিফটা নিয়ে আসতে পারতাম ইজ দ্য হোল প্রবলেম আমার তো রিপোর্টটা নিয়ে আসতে হবে না
Exception to the report filed by the petitioner, a report of state respondents, comma, filed by the petitioner is taken on record. Mr. Johansson, learned advocate appearing for state na kore এটা করো DPSC Paschim Medinipur.
I am for the District Primary School Council, Paschim Medinipur.
For the DPSC Paschim Medinipur seeking accommodation. 15th পরে বলো 2 weeks after the vacation. 2 weeks after the vacation কবে হচ্ছে ডেটটা বলো
10th.
My lord, let it be fixed, my lord, prior to 10 or my lord, after
Not prior to
19th,
10.
my lord, I shall not be here, my lord, out of station for 1 week. That is, that my lord, from 13th to 19th, my lord. Kindly, my lord.
10th বললো kindly try to take.
First week, my lord, at any day, my lord, or my lord, third week.
On 16th then
No, my lord, I shall come back on 19th or 20th, my lord. I shall not be here for 1 week, my lord, only.
এগুলোকে লাল করো
Or before 10, my lord.
ছুটি দেয় না
I don't have any objection.
23rd January মানে এই অনেকটা পিছিয়ে যাবে ঠিক আছে 9th এ রাখো 9th 9th
My lord, then my lord, 8th, my lord, from 9th, my lord, I shall not be here.
the difficulty is a Friday I will be taking
8 or 7th or 5th.
no
any day,
7th
my lord.
on the Fridays the miscellaneous matters will be taken up.
Oh.
So 9th is the Friday, 16th is Friday, all the Fridays then it go to 30th. On 9th,
Then, my lord, there will be some problem to me, my lord, because on 9th, my lord, from 9th on and from 9th to 19th, my lord, I have some problem. I shall not be here, my lord.
9th এ রাখো, 9th.
Okay,
Do the matter and then
I shall try to do. My lord, in item number 9, this is the
I am for the petitioner, my lord.
organizer teacher, my lord.
Matter relating to my lord, organizer, teacher.
My lord, this writ petition is not maintainable.
My lord,
why?
I am not placing my matter,
Yes.
my lord. My
Yeah.
started there. My lord, what happened, my lord? Prior to 1995, there are several organizer, teacher, and school organizing school in West Bengal, my lord.
Oh,
My lord, a cut-off date was fixed in the year 1995, my lord, for approval and of the organizing teaching and non-teach organizing teachers, my lord, under primary school, my lord, department. My lord, petitioners before your lordships, my lord, have been, my lord, rendering their service in different schools in the district of, my lord, Hooghly, my lord. Kindly see, my lord, page 6, my lord, I have stated, my lord, their name of the school, their names, etc., my lord. Now, my lord,
several lead petitions were filed, my lord, for their approval and permanent service, my lord, in the under primary school and their recognition, my lord. Yeah, and my lord, the same where my lord went up to the my lord honorable apex court, my lord. My lord, kindly see, my lord, the order passed in my lord, passed on my lord 6th January 2026, 16, my lord, before the my lord honorable apex court, my lord. The petitioners are also, my lord.
কি জাজমেন্ট?
সুপ্রিম কোর্টের জাজমেন্ট কোনটা আছে তোমার কাছে?
এটার মধ্যে আছে?
এটার মধ্যে নেই।
তাহলে কি আমি কি সব নিয়ে এসেছি এখানে?
No, my lord, in this seat petition, my lord, we are praying, my lord, only, my lord, thereafter, my lord, honorable apex court, my lord, come to a conclusion and handed over to the same, my lord, upon the my lord, West Bengal Legal Service Authority, my lord, to prepare a panel for the my lord organizing teaching and non-teaching staff, or organized teachers, my lord, including the petitioners also, my lord, before the honorable apex court, and also well, read petition also filed before this honorable court, my lord. Now, my lord, a list was prepared by the State Legal Service Authority, my lord. Now, my lord, the same was not published till date, my lord. Accordingly, my lord, petitioner is not in a position, my lord, whether their names are in the said list or not. What is the status of their position, my lord, in the list or not? My lord, they made prayer, my lord, before the authority, my lord. My lord, kindly see, my lord, come to my lord, my prayer, my lord. Representation also made. Only just, my lord, to intimate their status in the said list and whether their names are there or not. My lord, annexure P3, my lord, page number 46. Representation was made, my lord, 9th January 2025. Request for providing status report of the undersigned who are the organizing teachers in respect of the verification report as was prepared by the authorities in terms of the order of the Honorable of the Supreme Court of India in civil appeal number 4774 of 2018. And the name of the petitioner is also there, my lord, and my lord, the same was, my lord, sent through speed post. Track record is there, my lord. Now, what happened, my lord? In the similar circumstances like that of this petition, my lord, a writ application was moved before this honorable court in the year 2024, my lord, with a prayer for status report, my lord. My lord, the said writ petition was, my lord, dismissed, my lord, imposing cost by the honorable justice, my lord, Gangobadhyay, my lord. Well, against that, my lord, an appeal was preferred before this honorable court, my lord, and well, appeal court, my lord, by setting aside the judgment of that order, my lord, directed the authorities, my lord, to disclose whether the name of the petitioners were in the list or not, my lord. That was, my lord, the order. I am handing over the order of the honorable. And thereafter, my lord, the state authority, my lord, filed a review application against the order of the honorable division bench, and ultimately, my lord, the honorable division bench passed an order directing the state authorities to dispose of the to furnish the report as was prayed by the petitioners, my lord.
Where is the order of the honorable division bench?
My lord,
Order of the honorable division bench.
my lord, this one. হ্যাঁ দাদা ইনফরমেশন অর্ডার ইনফরমেশন আচ্ছা আচ্ছা দিয়ে দিচ্ছি দাদা
Where is the order passed in the mat?
লর্ডশিপ
Where is the order? Copy of the order passed in the mat. Appeal.
মানে this one,
This is review.
No, my lord, this is the order passed in your lord, appeal. একটা দিচ্ছি পরে দিচ্ছি। আরে ভাই, সবই আছে তোর কাছে, সব আছে আবার বলছিস। আচ্ছা, নেই আমার তো আছে প্রাইমারি।
Sir, wait. What are we doing?
সরি
Deposit back and I just get going to publish. Yes.
তোরা ফাইল পড়েছি।
What is
Now,
your
my lord, my prayer is, my lord, only prayer to my lord, to consider my representation, my lord, and to my lord furnish the status report in respect, my lord, of my candidature, my lord. I have already submitted the, my lord, before the verification committee, my application, my lord, case 36, annexure P2, my lord, in respect of my lord, civil appeal number 471,
Page 36.
case 36, my lord.
Page
The
36.
receipt showing that, my lord, I have submitted my application for verification of my candidature before the verification committee in terms of the order passed by the Honorable Supreme Court, my lord.
Which?
And it's up to my lord, this was received on, my lord, 12th
Where is
July
it?
2020.
Where is your representation? Where is your representation at page?
It's 36, my lord.
36 is receipt. Yes.
Representation is, my lord, annexure P3, my lord, is 46.
Where is Mr. Biswas?
There is no averment in the writ petition. Malad that malad the two condition is malad necessary. Either malad he has to be a member of 1257 of the organizer teacher. Malad no malad the
So
order is annexed in the writ petition. Malad he has not said, malad subject to correction I have checked up. Malad no averment that he was the member of 1257 of the malad the organizer teacher. Or my lord, he was party to that writ petition only where the Supreme Court is specifically said. Only those two were considered or sent to the Malad Legal Aid Service Authority. Remember, Malad, where is Malad? No averment is there. Nothing Malad annexed, no averment is there.
how many total candidates were there till 25th April 2018?
Yes, Malad, there are so many petitions were filed in the Supreme Court, thousands Malad applicants. Malad, the Supreme Court has specifically in an order, Malad 1257 who were member of the organizer teacher, and Malad the writ petition was specified that those who were party to the writ proceeding before the High Court, those will be only considered. Where is Malad, even there is no averment in the petition that either of the two is satisfied. Neither 1257 nor in the writ petition. On the contrary, he has mentioned Malad the other SLP number.
Okay.
And Malad, he has directly questioned the Malad the legal aid, Malad the authorities, Malad the report. Malad there, Malad the Supreme Court, Malad the last, Malad the matter, your lordship, I have shown your lordship that the Supreme Court has categorically stated, Malad, it was Malad the observed by the Supreme Court that no court shall entertain any of the challenge or dispute.
That he has challenged the report?
Malad, in paragraph, I tell your lordship, Malad, your lordship kindly come to Malad. Malad, just Malad. Malad, paragraph 12, page 11, your lordship kindly see. Malad, on and from 11. Thereafter, so much time has gone, but your petitioner did not give any relief till now. As per order of the Honorable Supreme Court, everything is the hand of the said verification committee. But verification committee remains silent, and they are not taking a single step for appointment of your petitioner. Next, that March prior to 1995, the petitioners have been rendering our service in the respective school as aforesaid, and several lead petitioners were disposed of by the Honorable High Court, Calcutta. Thereafter, the said matters went up to Supreme Court. The next also, my lord, the page 12, submitted by the learned counsel appearing for the some organizations who were not within the list of aforesaid 203%. Ultimately, 200 something persons were favored with the appointment letter. 203 were ultimately after scrutinize everything and verification, 203 matter the applicants were given, persons were given appointment, and that report was submitted before the Supreme Court, and Supreme Court disposed of all the contempt application. Next paragraph, your lordship, it is, if it is so, it would be open to them to approach the verification committee on or before 29th February 2018, so as to show that they are duly qualified as other organizer teachers as per rule in force as on 14 September 1995. They are trying to make out a new case here. A new challenge. They were below age of 60 years as on today. We are sure that as and when such an application is made, the verification committee will look into their grievance and take appropriate. Thereafter, again, he is questioning the committee's action. So far as other 5616 organizer teacher, as per list furnished by the Amarjit Singh Bedi, the learned counsel.
This is the order of the Honorable Apex Court, my lord. It is under quotation, my lord. He is reading all these things, my lord.
Yes, my lord. Paragraph 12, my lord.
Paragraph 14, my lord.
Dada, I boleni, dada.
Quoted the order of the Honorable Apex Court, my lord.
Yes, yes, Mr. Biswas.
This is the
under quotation.
What I am trying to submit before your lordship, paragraph 12, he has made the allegation against the committee. That committee is silent. This was the observation of the Supreme Court. He has quoted, not annexed in the Thereafter, my lord, paragraph 15. That from the aforesaid it is crystal clear that in respect of 5616 number of candidates as aforesaid, the same was already been completed and submitted before the verification committee. But again, my lord, it was, my lord, that paragraph 12, the silent, my lord, he has justifying the why the committee was silent. That is, my lord, the judgment of paragraph 10, my lord, in the morning's matter, that no challenge, no dispute by any court of law.
My lord, it cannot be said as well as it's challenge, my lord. Since, my lord, petitioner has not getting
Yes,
any
yes.
information, that is why, my lord, this statement was made, my lord.
Thereafter, my lord, this writ petition is not mental. There is no, your lordship will not find a single averment that he was party to the, my lord, that proceedings and 1257
Who
members.
are these persons?
It's very difficult to say because the, my lord, the council is not made party, the appointing authority, the council.
What was the cutoff date on which the applications were to be placed before the verification committee?
My lord, that I have to, my lord, bring all the, my lord, the order, my lord, because nothing is annexed in the, my lord, the.
Supposing they do not qualify as regards the two conditions, whether any writ petition was filed by them before the court,
Number
whether the last date, which was 28th or something of April 2018, was also they qualified or not. So how do these writ petitions have been filed?
Also, the memorandum of that organizing committee that he was the member of 1257. Other than, my lord, these two conditions and last, my lord, the cut-off date, my lord, he has to satisfy your lordship that the condition, two condition, 1257 and that writ petition. He was party to that writ petition.
If it is not so, then they cannot.
My lord, I just tell you from the, my lord, my memory, my lord, I am telling your lordship.
Sir, wait.
My lord, I obtained the certificate copy. That is why, my lord, the old records I find from the, my lord, I found from the, my lord, the High Court, my lord, and shown, my lord, all the courts after, my lord, showing this, my lord, certificate copy, all the writ petitions were then dismissed, my lord, the dismissed. And I send it to the Supreme Court also, my lord, as the counterpart of our. Because so many persons were, my lord, filing the SLP and claiming that I was the party to the proceedings. That is why we obtained the certificate copy from the, my lord, the High Court. But the old record, my lord, it was went to the, my lord, the Khidirpur, my lord, then record was brought to the court. Then I obtained the certificate copy.
Then where is your application before the verification committee? That has been annexed.
Counterpart, my lord, the page 36, my lord, the application was received by the verification committee.
When did you file the application?
My lord, 12 July 2018, my lord.
12 July.
My lord,
And what was the order cutoff date?
Received, my lord, showing this, all this, my lord. Obviously, my lord, within the cut-off date, otherwise they will not receive my application, my lord. My lord, they have received, my lord, my application.
They ought to have, my lord, annex the copy of the order. এই অর্ডার গুলো সব বার করতে সব তখন অর্গানাইজার টিচারের অর্ডার গুলো বার করেছিল।
So it would be open to them to approach the verification committee orders report. So as to show the duly qualified that other features as to.
My lord, keep it after vacation, my lord. I will come with all the orders and, my lord, satisfy your order.
Come to page 12 of the writ petition.
12.
This also you also take instruction.
My lord.
Because it is clear that they have, if it is so, it would be open to them to approach the verification committee on or before 29th of February 2018. Correct?
Yes.
These petitioners have filed on 12 July 2018, 13th July.
After the, my lord, cut-off date.
After this cut-off. And the other date is, see, at page 13.
Yes, my lord.
Having heard the learned advocate counsels appearing, this
Yes.
para 16,
Yes.
the last portion, we direct the Secretary West Bengal State Legal Service to verify the remaining grievance of the appellants and the interveners impleading applicants as on 25th April 2018.
18.
In that aspect also it is delay.
My lord, that two cut-off dates.
Yes. Now, whether these petitioners qualify by filing their application
My
on
best-
July 2018,
36 and 37, my lord, as per their, my lord, application, page 36 and
37.
37. All, my lord, dates are after, my lord,
That cut-off date.
April and
then
36 and 37. July and 13th July. Ultimately, 203 persons were given appointment at the age of 56, 57, 58.
yes. 25th April.
What is 20 that is fixed by the Honorable Apex Court, na?
My lord, only one thing, my lord, I just draw your lordship's attention. My lord, kindly come to page 2. My lord, I do not know the age. My lord, he has said, my lord, age about 53 years. My lord, just, I do not know, there is no averment. My lord, if it is the age of 43 years today, if he or she is the age of 43 years today, then, my lord, I am asking myself, in the year 1993, before 1993, what was the age of the petitioner? That is why that he served as organizer teacher. Am I clear to your lordship?
49. What will be his age at that point?
43 years, page 7,
45,
petitioner
47.
7,
11 years.
11 years. How, my lord, a person served below 18 as organizer teacher? My lord, I am asking myself.
Yes, sir.
My lord, that is why
That's
Supreme
10
Court
also.
categorically mentioned 1 to
10.
57.
10 also 43 years. 10.
Even, my lord, Supreme Court hold one judgment, my lord, I have seen that somehow, my lord, they are tried to be a member of 1 to 57
That-
in that group.
47. Then in July 2018, what was their age?
July 18, my lord.
তাহলে হলো 18 থেকে
কত point?
93 থেকে 18 হিসাব
Ish. তাই তো বললাম।
93 থেকে
হিসাব করো।
So 2nd April.
Petition number 5, 6, 7, none of the
10 1043 10 11 8 ও হবে না 6 ধরলে 17 এটা বলছে 2018
আচ্ছা।
ডেট অফ বার্থ দেয়নি তো চেক করতে হবে ডেট অফ বার্থ কত আছে
because date of, my lord, as of today, my lord, date of affirmation of the writ petition. Because Uttam Kumar date is, my lord, 57 years.
Yes.
One, in the jural portion, my lord, it is mentioned 57 years. So therefore, my lord, as per the, my lord, as of the affirmation of this writ petition, 2025, February 25, their age is, my lord, 43, 45, 47, 43. How, my lord, they were organized a teacher in
point of time.
before 1993. When a 10 years boy, 11 years boy was a teacher, as organizer teacher.
Okay.
My lord, this writ petition should be dismissed with cost, my lord.
And about 57, what was his age?
57.
7.
57 বাজার 25 বাদ দিলে কত হয় 8,106
57 will be 21.
21. My lord, I could have, my lord, understood, my lord, after 18 years, my lord.
59 already. Over this many dismissed.
There are also order of justice, Dipankar Datta
Yes.
at that point of time, my lord, in the division bench.
Yes.
My lord, you already bring all the orders.
Okay. Ashun.
My
Affidavit
lord, in
of
this
filed on behalf of the petitioner
in this matter, I am for the state respondent.
cannot record.
My lord, in this matter, my lord, I am for the state respondents. There is a delay. My lord, they have filed this representation, which is at 46, at page 46, my lord. Kindly come to. This is, my lord, submitted on 9th January 2025. After the, my lord, that filing of that petition, filing of the application in the year 2018, my lord, at page, my lord, 36.
My lord, may I submit one thing?
This representation has been filed, my lord, after a delay of 7 years, almost.
My lord,
Therefore, on the
my lord,
basis of this delay,
my lord,
this
similar-
writ petition should be
similar
dismissed, my lord.
application was disposed of, my lord, by the Honorable High Court, my lord. But there is a-
In that is separate issue.
Another thing, my lord,
Affidavit of service.
Uttam Kumar Ghosh, my lord,
Affidavit of service.
was the, my lord, one of the petitioner before the one Honorable told, my lord. Civil Appeal number 4774 of 2018, my lord. Allow me, my lord, to, my lord, place a supplementary affidavit to that effect, my lord. My lord, disclosing their
You dismiss the writ petition.
my lord, kindly, allow me, my lord.
No.
My lord,
After April 2018, you have filed your application. No locus to file a writ petition
but
for your consideration.
I am the party of the, my lord, petitioner before the Honorable Supreme Court, my lord.
Huh.
That is the, my lord,
অনেক পার্টি আছে
my lord, allow me to submit a supplementary affidavit, my lord, disclosing that they are also, my lord, party of the before the Honorable Supreme Court of India, my lord.
Who?
My
Who
lord,
were parties?
yeah, Mr. Uttam Kumar Ghosh, my lord. He has also Civil Appeal number 4774.
So who asked Mr. Uttam Kumar goes to take other 10 persons with him and file a writ petition before the court? The age of the persons at 43, you justify how they could be an organizer teacher on such date.
I have to, my lord, taking information, my lord, from them. my lord.
Take information from Mr. Ghosh. Where is he?
My lord, allow me, my lord, to-
Where is he? If he is an appellant before the Honorable Supreme Court, then why he has taken 10 persons with him? You're wasting the court's time.
Then, my lord, this was not disclosed in the petition, my lord. Allow me, my lord, their status before the Honorable Supreme Court.
Whose status? Who is petition number 2? You tell me. What was his age in the year 1995?
My lord, my lord, cut about date was that.
No, what was his age in 1995?
And they have to, my lord, take instruction, further instruction, my lord, to file it.
Tell me, just back calculate and subtract and tell me what was the age of petition number 2
That
on.
is very correct. My lord, in the
Then-
year 1995, their age is not permitted to appoint as an organized teacher and not as a teacher of the institution, my lord. That's true. But my lord, allow me only
Produce the date of birth of all these persons.
to take instruction, further instruction, and to file a supplementary affidavit disclosing all the things, my lord.
Please.
My lord, STA, date of birth, 2nd March 1980. My lord, if he 80, my lord, 93 is, my lord, 13 years of age. Even he has not passed, my lord, the Madhyamik.
Then
My lord, he taught, my lord, the primary grade.
In the year 2018, they are all.
Next page, your lordship, the 29. Date of birth is 78. Own documents he has annexed.
And
Then my lord, page 31.
Two.
82.
I am praying for my submitting
everything on record.
34. Page 82.
disclosing all these things, my lord, before your lordship. Since my lord, this has been come to my knowledge just now, my lord, allow me to.
Who has filed the writ petition? Not you.
No, my lord.
Who has drafted it?
My lord, kindly allow me.
Sorry, this is very bad state of affairs.
Lordship.
Now you have drafted this. Now you say that it was not within your knowledge. You have annexing the Aadhaar card. Who are these persons?
29 to my knowledge.
My lord, I am taking. Just my lord.
Person before the Honorable Supreme Court, he files a writ petition along with persons who were minor at the time when the rules were in effect at 14 September 1995.
That has been happened, my lord. Then, my lord, allow me to take instruction, my lord. That cannot be, my lord. To take, my lord, the
Dismiss the writ petition. Right.
my lord, only, my lord, 1 week, my lord.
Cannot file frivolous applications like this.
Supplementary affidavit, my lord.
What you will state in the supplementary affidavit?
Possibly, my lord. Number 1 is. আপনার বয়স তো দেখতে পাচ্ছি ঠিক আছে
Mr. Bishwas, petition number 1 was an appellant before the Honorable Supreme Court.
Well, I have to check up, my lord. This type of petition, my lord, I really have to check up.
বয়স কত তার
My lord, he has to annex this.
Sir, please don't consult with your client in court. Enough consultation has been made in the chamber.
Sorry, my lord.
Right?
Sorry, my lord. Well, I am praying, my lord, just supplementary.
He was an appellant before the Honorable Supreme Court.
My lord, I have to check up, my lord, whether, my lord, he was one member of 1257 and the writ petitioners before the High Court.
Authority, they have made party, but I don't know whether notice is served upon them that today the matter will be heard.
Even the, my lord,
But the DPSC has not been made party.
the appointing
DPSC.
authorities, my lord, they are all
Under
from the Hooghly Primary School Councils, my lord. They have not made
My
party.
status report in the list, my lord. Nothing, my lord. I am not praying
This
for
frivolous.
appointment, my lord. Whether my name was in the list or not, that is my only my lord.
No.
Annexed all.
That is only my prayer. Whether status report of the.
Then
If you don't qualify within the cutoff, how will name will figure?
And after a lapse of 7 years, they have filed filed one representation. That is another person has made the.
Already allowed, and division bench passed an order directing them to furnish the status board. They have already furnished their status board in the year 2025.
My lord,
They have also-
number 2, 5, 6, 7. What is the answer, my lord? My understand can answer before your lordship.
7,
In
10,
respect of
10.
2, 5, 6, 7, 10. They all were minor at that point of time. Nothing is stated when he was the organizer teacher, when, what school he was organizer teacher, in which school.
Allow me to file a supplementary evidence.
No. No supplementary affidavit.
Only just disclosing the kind of
In
submitting the order of the Honorable Supreme Court, whether they are a party in the Supreme Court or not, my lord, that just only just. According to them, they are also in the Supreme
8 years.
Court.
no, no. You know? You give your affidavit of service? দিয়েছিল ঠিক আছে আগের দিনই দিয়ে আছে কেটে দিন the petitioners have you paid the court fees?
Yes, my lord.
Where is the document?
Deficit court fees has been paid, my lord. Dekha.
Document showing deposit of deficit court fees is taken on record. The petitioners
তো আমাকে লাগায়
for direction upon the respondent authority for
বড় বেতন এগুলো তো
implementation of order passed by the Honorable Supreme Court on 3rd May 2018 in Civil Appeal number 4772 of 2018 and for consideration of their representation dated 14th February 2023. The petitioners contains that they are the formed association in the name of West Bengal Organizers Primary Teachers Association. And full stop. As per the direction of the Honorable Supreme Court, the petitioners were supposed to be appointed upon verification by the committee. The petitioners have not been intimated as to whether the petitioner's name figured in the panel prepared by the verification committee. Where is your representation?
Representation is at page 48,
46.
47, 46.
All are the petitioners here?
Yes.
competition
46.
In the 46. And the receipts, sir, where are the receipts of submission of application?
that is starting from
My lord.
53 page 53 54 একটা দুটো লাগিয়েছে ওটা লাগিয়ে 53 54 55
page 36 my lord.
আবার 36 বলছে ওটা চাই
36 নয় ওটা 54 my lord.
No, no.
হ্যাঁ হ্যাঁ রিপ্রেজেন্টেশনটা
Representation page 54.
No, when did they file their application before the verification committee? He has shown
yes
That is
around
37.
ডেটটা হলো জুলাই জুলাই না
13 July and 12 July. 2 days.
হ্যাঁ 12 জুলাই 13 জুলাই 2018
And these minor child, my lord, the persons filed also, my lord. 13 July, 12 July.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10. All the petitioners.
কেউ মেম্বার এগুলো তখন করলো না আপনার ডিলে করলো এগুলো ডিলের জন্য ওই তখন করে নেওয়া আমি তা বলছি না আমি বলছি তখন ঠিক করে নিলে গন্ডগোলটা আমরা চেঁচাই না অর্ধেক নেই
কি বললাম না? Hence this writ petition. Mr. Ratul Biswas, learned advocate, appearing for the appearing for the board at the outset indicates that some of the petitioners at the time when this organization was formed were minors. Therefore, their prayers cannot be considered. Moreover, as per the acknowledgement receipts, it shows that the applications have been furnished after the cut-off date of the Honorable Supreme Court, fixed by the Honorable Supreme Court. And therefore, the applications are not entertainable. In view of the above submission, the board is directed, respondent board is directed to furnish a report on the returnable date. Place this matter on 6th. Furnish report on the returnable date. Place this matter on 6th February. Mr. Biswas, in page 36, there are also serial numbers given. Serial number civil appeal.
Legal aid authority is the appropriate person to ascertain.
No such list was furnished to the board.
No. Nothing. Only the legal aid authority will come and say. Or the principal secretary government of West Bengal, my learned friend can bring all the reports.
My lord, this is done by the State Legal Services Authority, and they have made party to this writ petition as my lord respondent number 5, my lord. Let a direction be passed upon the my lord State Legal Services Authority, my lord, to verify that whether all these my lord applications submitted on that date specified in this writ petition. They can, my lord, say we are not the authority to maintain all these things.
Petitioner is directed to intimate the Secretary, State Legal Services Authority, of the next date of hearing. Act over a line dealing, none appears on behalf of the West Bengal Secretary, State Legal Services Authority, West Bengal. Yeah. On 6th February, this will appear. Not report on that day and give a notice.
It has been briefed. Deeply honest. Yes.
They have not considered this.
They have not considered
So
it.
your one grievances is that this electric connection is to be disconnected.
Disconnected.
And next,
next grievance is to give us the security deposit, which they haven't.
of your
Paid.
mother's
Absolutely,
connection.
Lordship.
That is to be treated as a permanent disconnection,
Yeah.
and the refund is to be made.
Absolutely,
Whatever
Lordship.
the amount is
And-
pending.
Yes, Lordship.
Yes.
And the
Next.
third is, Lordship, the wrong which they have committed, mainly the respondent number 3 is concerned, in collusion with the private respondents. They were in conspiracy, and the collusion that is evident from the record, and there is a clear violation of the rules that are enunciated in the Electricity Act. They have clearly violated it. I'm trying to indicate, Lordship.
Yes. So what you want?
I do want the permanent disconnection of the electricity.
These are the three grievances.
These three grievances.
Okay. Yes.
My lord, I am for the private respondents.
Yes.
It is an admitted fact that the private respondents are in occupation of the property. Whether illegally or legally, the civil suit is pending, that will be decided thereon. So far as the connection of the 2 meter,
Who has filed the civil suit
they have filed the civil suit.
against you?
Yes, my
What
lord.
is the prayer in the civil suit?
Eviction, my lord.
Eviction.
Eviction.
Okay.
Now, so far as the connection is concerned, my lord, the private respondent number 4 to 6 were residing there. Initially, the connection that was there in existence was disconnected by the petitioners. Later on, the private respondent number 4.
No, you have applied for the connection.
Yes, I applied, supplied the requisite documents, and they supplied us the
What
connection.
document you supplied for?
On the last, all the gas connection, the documents,
Is in your name you applied for?
yes, my lord, in my name. That happened much prior to the disconnection that they are alleging.
But how you applied for?
By submitting the documents, my lord.
Submitting the document with regard to you are the daughter of the.
No connection with that. That is what I'm indicating, my lord. The respondent number 4 has no connection with the disconnection that they are alleging. That they are alleging, that they are blaming on the respondent number 4, the petitioners.
No.
We have applied for a connection. We have got a connection, and all this happened much before the
You have
disconnection.
applied for the connection on what ground? As a occupier or as a legal layer?
As a occupier, my lord.
So occupier is your application. Show me as you occupier. you
Application, my lord, those are already been submitted on the last.
That I find it. That's why I'm asking you. I am giving an opportunity.
Yes, my lord.
You. Don't.
If,
I have already gone through the document of the authority.
those are the documents we submitted, my lord, before the
But
electricity
in
board.
the application, what you have submitted?
That we need a connection since there has been disconnection by the petitioners.
Where is the document?
Well, that last occasion that was with file original.
Those are that
Original file was lying with the record.
That is the only application made by the respondent number.
The original file ta kor. Yes. The first is application. Thereafter, my lord, is Aadhaar card, PAN card, and then my lord, voter card, and then my lord, Indian gas connection documents, and then my lord, bank passport, savings banks accounts within the name of the same, mentioning same address.
But Lordship, what is
That
the
you have considered an
page
effect.
number 60, annexed P13? They have admitted. Page number 60.
Just a minute. And so this is the application.
That is the only application made by respondent number
With
4.
regard to the disconnection, what do you what
We have nothing to say. We have nothing to do with the disconnection, my lord.
who has applied for?
I have not. Respondent number 4 has not applied for it. The signature is also mismatching, my lord. I have even indicated that on the last occasion. That is the vernacular language signature that is there on the PAN card of the respondent number 4 is totally mismatching, my lord. It's visibly distinguishable from the signature that is there on the application that they are relying on and blaming us on.
This is not your signature.
No, not at all, my lord. Kindly.
You have disconnected.
There is some, so far my part is concerned, my lord, there is some mistake that I have seen. That's why, my lord, from the very outset, I submit before your lordship. My lord, if your lordship is of the opinion, we will reconnect. We have no, my lord,
So you want the
difficulties.
reconnection or refund charge?
I want the disconnection as well as the refund charge.
Disconnect. What disconnection?
Disconnection of the meter.
Cannot be. He is the occupier. He is entitled unless he is evicted from the property in question. He is entitled for the electricity.
As per larger.
They have admitted.
Maybe.
They have admitted.
What admitted?
Page number, come to page
What
number
admitted?
60.
Tell me.
That they have admitted, though you have stated her as your deceased mother, they respondent number 4 criminally
Which
mixed.
page?
Page number 60,
That is
annexed P13, as well as this second report by them.
Page number
60, annexed P13.
60.
60.
They have done it contemporaneously.
On 15, an objection letter was received for reference to so from applied for permanent disconnection, existing connection having which has been named.
It is with regard.
Correct.
It is with regard to disconnection of the.
Correct. That's why this court has called for the record. Call for the record. They are having only one document, that is the letter. Correct. This letter. So this letter then is denying that. Is denying that.
Lordship,
The signature.
Absolutely.
If you any, I will give liberty. If any objection, you file a police complaint before the
Lordship, the
and take
police
a-
authority is not cooperating with us for the
Okay,
investigation.
by the side there is a court in action of the police. By this after this wall, there is a court for the inaction. Correct.
Lordship, my simple prayer is the
The
disconnection of this
petitioner
meter.
has filed the present application. Praying for. Filed an application for disconnection of the electric connection provided to the private respondent, namely, in whose name it was provided?
Private respondent 4, 5, and 6.
All three. In the three
One. The name of private respondent number 4.
in the name of this, the name of Suniti Maji, the private respondent number 4. He submits that. See, the private respondent number 4 has obtained the electric connection fraudulently by showing that she is the daughter of late
Pushparani Chakraborty.
Pushparani Chakraborty. Though she is not the daughter of Pushparani Chakraborty. Full stop. The further grievance of the petitioner is that the private respondent number 4 has made an application before the WBSCDCL for disconnection of the meter connection, which was provided in the name of the grandmother.
Lordship,
In
I'm
the name of
seeking you, Lordship, kindly, I'm relying on this judgment.
in the name of the grandmother of the petitioner. And in the application which the private respondent has requested the WPSCDCL for disconnection of the electric connection. In that application, she has narrated that she is the daughter of the deceased. What naam diya na? Kya bola? Pushparani. Another prayer of the petitioner before this court that the electric connection which was provided in the name of the grandmother of the petitioner, but the WBSCDCL has not refunded the security deposit. The security deposit is to be refunded. Full stop. Learned counsel for the full stop. This court has called for the original record from the WBSCDCL with regard to the application filed by the private respondent for disconnection of the electric connection, which was provided in the name of the grandmother of the petitioner. The authority has produced the file wherein it is found that one application was filed on 22nd of May 2024. What is the name? In the name of Suniti Naji, for permanent disconnection of the meter connection bin consumers ID number 15302425925. Full stop. The authorities have also produced the original file wherein the private respondent has applied for grant of electric connection. In the said file, it is found that the original form submitted by the private respondent along with the connected document, that is Aadhaar card, election identity card, gas connection card, and the copy of the suit pending before the copy of the case filed before the subdivisional executive magistrate at Barasa. The grievance of the petitioner that the private respondent has by mentioning that she is the daughter of the deceased, ye naam bolchi, Reverend Pushpa Rani Chakravarti, has applied for disconnection of the electric connection which was provided in the name of Pushpa Rani Chakravarti. This court considered the original application filed by the private respondent number 5. The learned counsel for the private respondent number 5 has denied that the signature appearing in the said letter is not of the private respondent. This court find that only on the one paper application the authority had disconnected the electric connection of the Pushpa Rani Chakravarti, but no proceeding has been drawn. Now the private respondent number 4 has taken that the signature is not in the name of the private respondent. No signature appearing in the said application is not of the private respondent number. Accordingly, this WBSCDCL is directed to forward this copy of the application submitted by the alleged to have been submitted by the private respondent number 4 to the concerned police authority, and if within a period of 1 week from date, and if any complaint is received by the concerned police authority, the police authority investigate the matter whether the private respondent has applied for disconnection of the electric connection in terms of this letter dated 22/5/2024. Full stop. And to take appropriate steps in accordance with laws. As regard the grant of electric connection, this court find that Suniti Maji, that is the respondent number 4, has applied for the electric connection in her name by disclosing her identity in the said application, incorporating the documents. And this court did not find any contrary document that Suniti Maji has misrepresented before the authority that she is the daughter of the, what is the name? Pushpa Rani Chakravarti. The petitioner did not, it is not the prayer of the petitioner that the electricity connection which has been disconnected is to be restored. The only grievance of the petitioner that the electric connection which was in the name of the Pushpa Rani Chakravarti was disconnected, that's may be made as a permanent disconnection, and the security deposit
as well as the restoration also. New application can be filed by the petitioners as well.
That we always will.
That always permanent, and the security deposit made by Srimati Pushpa Rani Chakravarti at the time of grant of obtaining the electric connection may be refunded.
And what about
in view of the above, the electricity connection, in view of the above, the WBSCDCL is directed that the electricity connection which was provided in the name of Reva Rani Chakravarti, which was disconnected, be made as a permanent disconnection, and the security deposit may be refunded to the petitioner with the petitioners within a period of,
as your lordship,
2 weeks from the date of receipt of this order. Full stop.
With interest.
As regard the disconnection of the electric connection of the petitioner, respondent number 4 is concerned, this court finds that the petitioner have already initiated a civil case before the appropriate civil court, and the same is pending for eviction of the private respondent. Admittedly, the private respondent is in possession of the property in question. Thus, it is settled law that the illegal occupier is also entitled to get an electric connection. Thus, it is not proper for this court at this stage to pass any order for disconnection of the electric connection. But it is made clear that getting an electricity connection will not create any right title interest of the private respondent over the property in question.
Grateful to you.
Just indicating that the judgment which I have relied
My
upon
lord,
that squarely applies in our case, lordship.
my lord, may I be permitted to take back the original records?
The original records is written back to the learned advocate appearing for the WBSCDCL.
I'm grateful to your lordship.
WP is disposed.
Grateful to your lordship.
Deeply grateful.
दोनों फाइल दे ये भी ले लो Next.
Number 19.
My lord, I appear for the writ petitioner, my lord. This is, my lord, against termination of a works contract, my lord. And my lord, I was given, after termination, I was given a notice that if you don't vacate the entire premises within 15 days, you will be thrown out with the aid of police. I had, my lord, therefore mentioned the matter, my lord, in view of this urgency, my lord. I have served the respondents, my lord. 2, my lord, by speed registered post and 2 of them by hand, my lord. The first respondent being the GP, my lord, they did not accept because they said, unless leave is granted by the court, we will not accept without 48 hours notice. But they are, my lord, really not the real respondent. The other respondents perhaps are here, my lord.
If they want hard copy, who is your appearing?
I'm for the state authority.
State authority.
Here,
But I have not received any copy because they have served it by email, through email to them in the evening only. And we have just got the email copy. We have not received any instruction as of now. So if your lordship kindly make it after vacation. Or
I will record your submission. You undertake that he will not evict.
yes. Don't give effect to this letter that you, because today they'll throw me out, they say.
Till
Lordship,
8, 9,
already
10,
a
whatever,
reason
as,
order has been
as
passed.
per your convenient, I am fixing the date.
then your lordship make it next week.
Next week.
Yes, your
26,
lordship.
26.
On Monday.
Monday, there are so many matters.
Then on
Yes,
Tuesday, your
what
lordship.
what is the matter? Where is the notice? Mr. Singh, where is the notice?
My lord, kindly, my lord, allow me to use the supplementary affidavit, my lord. This letter was wrongly annexed, my lord. Page 10 of the supplementary affidavit, my lord, where they say that if I don't vacate within 15 days, I shall be thrown out with the aid of police, my lord. Let this be stayed, my lord, let them come.
Construction of proposed Rani Rasomani Green University near Tarkeshwar, Hubli. What has happened? You have not completed the work.
My lord, the project, I had to construct a G+7 educational institute.
Correct.
Now, my lord, this contract was for 1,000 odd days, my lord. In 2022, I was given this work order, my lord. I had to construct this building pursuant to a design given by them. My lord. This is under the terms of the contract, my lord. They give me the design only this year in February. And my lord, then they extend my time. The extended time is 20 December 2026. Within this time, my lord, they issued 2 show cause notice and now terminate. Against these 2 show cause notices, my lord, I prefer a writ. Then this is second round of litigation. I preferred a writ challenging those 2 show cause notices. The court did not interfere because in any event termination was not there till then. The matter went up till Supreme Court. Supreme Court said, go back, ask them to consider our representation. I should show the Supreme Court's order that if the payments are not made, the RA bills are not cleared, designs are not given, how could I? Court said, all right, these are contractual dispute. I am directing them to consider your representation. After coming, meanwhile, when the writ petition was pending, they terminate the contract. This is against termination, my lord. And my lord, also, secondly, the Supreme Court had said that consider their representation because what the point that we had raised were plausible, and the court said.
When the termination was done.
Yes, my lord. Termination happened on 18th July 25. Now,
Not challenge that.
earlier I had not challenged this. Now I have challenged the termination because termination happened.
July.
Yes, so this is the termination that I have challenged now.
This is
Yes.
the July order you are challenging.
Yes. No, because the Supreme Court had said that you consider the representation. So this process of representation and their consideration, their rejection of my consideration representation has happened only on 19th of November 2025. So 2 orders are under challenge: the termination of the contract and their rejection of my representation, which was rejected on 19th of November 25. They reject on 19th of November and then they issue this notice and say that if you don't vacate within 15 days, we'll throw you out with the aid of police. But I shall show from the face of records, my lord, the termination is contrary to their own terms of the purchase order, my lord. And further, my lord, the contract is subsisting. They give me design in February. They give extension in May, and in July they terminate, my lord. Well, it's still 1 year to complete the work. I said you make payment because under the contract you was.
Where is the termination order?
Yes, my lord. The termination letter, my lord, will find at page 244. P20. Well, I had to trouble the court because if I don't move this, 244. They should not throw me out before the writ petition is heard.
There is no this arbitration clause.
No arbitration clause. There's no arbitration. I have to go in suit. And before that, if I'm thrown out, my lord.
Whereas you were served with the so-called notice in this regard, and this office, itna, which has not been replied to the satisfaction of the engineering charge. Which department? PWD?
Yes, my lord.
So what about the measurement has been taken in terms of the 18 July?
No, nothing has been done, my lord. My lord, may I suggest this, my lord? My lord, their last letter by which I had to move this hurriedly, my lord. If I don't vacate by today, they'll throw me out. Let this be fixed on the reopening day, my lord. I shall serve my friends there. But in the meantime, let them not throw me out.
Now, sir. At
Now,
present,
sir.
yes, my lord.
So you are ready?
No.
What I propose to do, if suppose, what you propose to do, there is also the time limit is there. So I will request you not to pass any, not to evict, not to take any action in terms of the letter dated 5th December. Let the matter appear on 7 or 8.
Lord, this project is the public.
That's why I'm telling. That's why I'm telling. Now we are on 19. We are on 19. I am fixing on 7th or 8th.
Yes.
But
No.
tender issue.
Lots of kindly see the already fresh tender already issue.
When is the opening date?
Already issue.
Work order issue.
Already issue.
This
Not only
project-
that, my lord. The huge amount is the
I have invested, my lord, from 2020.
Lordship, 98.
You are not challenge this new tender notice.
No, my lord, because I have challenged my termination.
No, you.
If I participate in the tender, then I waive my term.
That's why you're not challenging.
No, because I have challenged the termination itself, my lord. And if I succeed, this subsequent tender will automatically go. And if I participate, then I accept the termination. That's the difficulty, my lord.
You could have been challenged that
Lordship.
tender notice which has been issued. You are not challenging the tender
My
notice.
lord will kindly appreciate. My lord, I have
Your tender was cancelled.
yes.
After the cancellation of tender, they have published a new e-tender or whatever the tender notice. Correct. Some third party you are not participated because you are challenging.
Yes.
But you are also not challenge that e-tender notice or tender notice whichever issued for the remaining work of the project in question. So now if the work order is issued to the third party, so how correctly the third party has to execute the work.
No, my lord, kindly appreciates, my lord. I have, my lord, invested in this property since 2021. I have constructed a portion of the work allotted to me. Meanwhile, this arbitrary termination has come in, despite, my lord, the Supreme Court directing them to consider the issues that we had raised. Now, to bypass everything, my lord, they, my lord, issue a work order to someone else, my lord. This has to be subject to the outcome of this.
Supreme Court has passed an order.
Yes, my lord. The Supreme Court's order is dated 10th October 2025.
10th October 25.
Yes.
The order.
Order, my lord, you'll find it page 397. So to bypass everything, they issue a new tender, and my lord, I'll have to. This is
397.
397, P32, my lord. And then, my lord, to make my writ petition infructuous, I'm threatened that I'll be thrown out of the property. Last volume.
Supreme Court ki bolche?
Bolo na je.
Yeah, nothing.
Division bench had said, my lord, kindly look at the division bench's order, my lord.
The division bench order.
Yes, my lord. Page 316.
16.
Sorry. 392. So I'm sorry, my lord, 392. And the relevant portion, my lord, will find paragraph 13 of the judgment. Paragraph 13 is at page 395. Although we are not minded to interfere with the order impugned and the decision of the learned single judge, the disputed questions of fact are involved and therefore writ petition are not maintainable. Nonetheless, we request the authorities to consider and decide the contents of the letter of 4th July 25 by passing a reasoned order.
Correct.
This is what Supreme Court also said. You decide.
Correct.
Now, my lord, they reject it.
Correct.
And, my lord, without any reason. So this order is also under challenge.
4th July.
4th July representation was rejected by them.
That you have challenged that the the contents of the letter, the 4th July passing a reason.
Yes,
The 4th July representation is connected with which order of the cancellation?
19th November, which is at page 403. 19 P34, my lord. This is without, my lord, considering the issues that we had raised. Complete non-application of mine I can show, because for this I'll have to show my issues that I had raised in my representation and how those have been dealt with, my lord. They reject this, they reject my representation. This is at page 403, my lord.
Yes.
I am against this letter as well as my termination. Both.
1911-25.
Yes, my lord. This is their order rejecting my representation.
No, that's not. Initially, 4th July, you have made a representation.
Yes.
Against which order? 4th July.
4th July was again my representation to them.
Correct.
To allow me to work, give my payments, because unless payments are made, I cannot continue with the construction. And I raised a series of issues.
I think that representation,
They terminated. Yes. Court said, you please dispose this off. Now they have disposed of. Normally, the first round of litigation did not have the termination, that the termination was not in existence. So I had to raise this in the, so this writ petition has the termination under challenge and this representation's rejection, my lord. While these two is pending, my lord, now they give this letter and they say you leave, otherwise we'll throw you out by the aid of police. So all that I was humbly submitting, my lord, will hear me out. But in the meantime, let us just not become infractuous, my lord. That was my only submission, my lord. This is why I had mentioned it yesterday, my lord. And I can take, my lord, through all the documents and the purchase order and show as to why the termination itself is wrong, my lord. And contrary to, on the face to the terms of the purchase order and on the face of it, my lord. I have invested huge sum of money in this project.
But you are not challenging the second tender notice.
I would kindly appreciate.
Second tender notice, the third party interest is accrued. So what can be done?
But before that, my interest is there, my lord, since 2021.
But you're silent over there. The second tender notice.
My lord, if I succeed,
You succeed. You could have been challenged that.
Lordship.
If you're not participating, you could have been challenged for staying up that. But you're not challenged that.
Very well, my lord. What I can do is, my lord, I shall challenge that also in this. Kindly allow me to do that. But in the meantime, let this not become infractuous.
Challenge now. After the when the tender was when tender notice was issued, the second tender notice was issued.
Lordship 21 me.
Huh?
Second notice was after.
When the second tender notice was issued.
Lordship, after the order of the writ court, thereafter writ petition already failed, my lord. Thereafter, on the basis of that writ already tender already issued.
Come with a good case.
According to the
kindly
division
protect
bench.
in the meantime, my lord.
Lordship, according to the division bench order.
Already second tender of party applied, work order issued to the.
My lord, kindly appreciates, my lord. Today, my lord, I have invested huge sum of money in this project. If I am thrown out, my lord, nothing.
Go for the damage. Go for the damage.
Lordship, kindly see the page number 404.
My lord, Supreme Court had and the division bench had directed them to my lord,
They are directed, but in the meantime, they have
8 crore
already initiated
paid.
the process for the second tender, and second tender is concluded now.
can they bypass the directives of the Supreme Court, my existing right in the asset that I have invested so much of money merely by issuing a second tender.
Party interest has accrued, so it is validated.
You are already representation already considered.
I have been instructed that work order has not yet been issued in favor of the third party. They may have been identified, but the work order has not been issued. The tender has been floated.
Participated, no?
If I participate, then I go by to this.
Number 404.
Very well, still, but I can still do that. I can still do that. But in the meantime, this has to be decided whether the termination is correct or not. Kindly, this will result in
that will decide it. If you got in your favor, then you will get the benefit in the damage. Nothing can.
Then allow me to, after vacation, allow me to place this writ petition at least.
So what you want?
Kindly let them not throw me out till the opening so that I can come and.
Representation already consider.
If I can show from the face of record that termination is contrary to terms, kindly.
On merit you come.
Yes.
I will hear on merit, but today I will not pass any order. In interim order, I will not pass. Come on the merit, I will hear. Let the affidavit complete, but sorry.
So my lord will kindly fix it on reopening day in that event. But I'll come and satisfy. My lord, I have to.
The petitioner has filed the present date application challenging. What you are challenging this order?
The termination letter.
Termination letter, where is
The termination letter is dated is at page 244, annexure P20, my lord.
244. Challenging the order of termination of the contract of the petitioner dated
18 July 25.
Dated 18th of July 2025.
And the decision dated 19th November 25.
And the where is that?
Page 403. my lord.
And the decision taken by the respondent authorities in terms of the order passed by the Honorable Division Bench as well as the Honorable Supreme Court. Challenge your own Resolution of the dated 19/11/2025 in terms of the order passed by the Honorable Division Bench as well as the Honorable Supreme Court. 19/11/2025. 19/11/2025. The petition is also challenged by way of supplement has also disclosed the communication dated 5th of December 2025, wherein the Executive Engineer PWD Hooghly Construction Division, Chowk Bazar, Hooghly, has directed the petitioner to arrange for removal of all unused construction materials and machineries, if any, from the work site within 15 days from the issuance of the memo, and if the petitioner failed to vacate the same, authority will take appropriate action in accordance. Counsel for the petitioner submitted the petitioner has initially made a representation for consideration of the case of the petitioner, but the same was not considered. Accordingly, the petitioner has filed the writ application before this court. The said writ application was dismissed by the coordinate bench of this court by an order dated 11 September 2020. Being agreed with the said order, the petitioner has prepared an appeal, and the appellate court has disposed of said appeal by requesting the authorities to consider and decide the representation submitted by the petitioner dated 4th of July 2025 and to pass the reasoned. Being agreed with the order passed by the Honorable Division Bench, the petitioner has preferred an SLP before the Honorable Supreme Court, and the Honorable Supreme Court has disposed of the SLP filed by the petitioner on 10th of October 2025 without interfering with the order passed by the Honorable Division Bench and requested the authorities to consider the petition filed by the the representation filed by the petitioner as early as possible. Good. Now the authorities have passed the order. On 19/11/2025, rejecting the representation of the petition. In the meantime, on 18th of July 2025, the contract of the petitioner also been cancelled, and now the authorities are directed the petitioner to vacate the premises in question. Counsel for the petitioner pays for an interim order restraining the authorities for giving any effect or further effect to the communication dated 5th of December 2025, wherein the opponent's authorities directed the petitioner to vacate the premises within a period of 15 days. Per contra, an advocate appearing for the respondent submit that the contract with respect of the petitioner has been cancelled on 18th of July 2025. The petitioner has not challenged the order of cancellation. In the meantime, petitioner has challenged the order of cancellation now in the present writ application after the period of 5 months. The further submitted in the meantime, the responsibilities have already rendered and the work order has been issued to the third party for completion. Third party for completion of the remaining work awarded to the petitioner. Full stop. If further submitted, if at this stage any order is passed and the work could not be completed, which has been awarded to the third party in terms of the second contract. At the learned counsel for the respective parties peruse the materials of the court. This court finds that the representation made by the petitioner was duly considered by the authorities and the same was rejected by an order dated 19/11/2025. In the meantime, on 18th of July 2025, the work order was cancelled. And after the cancellation of the work order, the authorities have issued the first tender notice for execution of the remaining work, and as per the submission made by the respondent, some third party has already been selected for completion of the remaining. Considering the above, this court find that the third party interest this court find that the authorities already cancelled the tender of the petition on 18th of July 2025. The representation filed by the petition was already been disposed of, rejecting the request of the petition on 19/11/2025. Now the third party interests are already been accrued. Thus, this court did not find any IFSI material to pass any interim order. Accordingly, interim order is refused.
Lordship, my appearance is kindly regularized.
Yes.
My appearance is kindly regularized.
Appearing for the state, the appearance of
AGP
the petition directed to serve the copy, na?
But the new tender will be subject to outcome of this writ petition. My lord, kindly at least.
Already tender.
Yes.
Already work order issue.
Sorry, come with a good case. Come with a good.
I'm deeply aware.
Lost. Come to
19, 20. Yes.
Yes, I am for the petition, Your Lordship. This is my affidavit of service, Your Lordship. Your Lordship, the matter relates to a tender procedure, Your Lordship. In the Alipur Zoo, Your Lordship, for the last, from the year 2024 till now, Your Lordship, there are two types of tender, Your Lordship. One is for an ice cream kiosk and another is the food purpose. As per the norms, Your Lordship, all the tenders and all the stalls should be in a designated area, not beyond that, Your Lordship. I have participated in the tender, Your Lordship. From the year 2024 till date, Your Lordship, 8 tenders has been called, Your Lordship, and every time it has been cancelled, citing the reason administrative purpose. That is the sole purpose. Why? The second, what is I am submitting before Lordship is that there are certain vendors, Your Lordship, because if you have to have a ingress and egress inside the zoo, Your Lordship, there is a designated area, and the government charges us, Your Lordship. We are going to supposedly pay for it, and we are designated area is given. We run our business. Now, the fact remains that if Your Lordship can call a record from the concerned authority, Your Lordship will find that there are multiple vendors who doesn't have a license. They might have participated in tender 2000, 2 years back, 3 years back, but still they are in operation. What I'm submitting is that for the last, from 2024 till date, I have given 5 examples where the tender has been called and cancelled, citing there is an administrative purpose. No definition has been given. On the last occasion I participated, they gave the same reason. There is administrative purpose, tender cancelled. I am at a representation. They again has called a tender, but no one knows the future of it.
Where here now?
My simple prayer, Lordship, there should be an investigation why this is happening, because for the last 8 tenders, citing administrative reasons.
So you are continuing with the tender?
No, I participate, but they're not. I am participating, but once I'm participating, the one process is done. They said it's cancelled, administrative purpose. So I am my simple.
What right you are having?
Your Lordship, for the last from 2024 till now, if they're calling for a tender, they're cancelling it. I have made a represent, let that be considered as well. Because why, Your Lordship, putting this question to myself, this is the government revenue.
Once they have placed the tender, but subsequently they came to, no, it is not required.
And that's why, Your Lordship,
whether the court can impose condition, yes, you have to complete the tender process.
Your Lordship, that's
No, the court can impose condition to the authority to complete do the tender process.
Your Lordship, this is a public money involved, and I have participated.
What for public money? What they have taken the amount from you?
No, Your Lordship, but they are technically allowing the unauthorized person to run the show. How can that is possible, Your Lordship?
Who is running the show?
Your Lordship,
Who is running? Where is the private party?
Because Your Lordship, I have participated.
What is your grievances? Your grievances is that 4 or 5 times they have
8 times, Your Lordship.
8 times they have issued the tender notice.
And citing the reason,
Subsequently they have
cancel it.
withdrawn that.
Administrative purpose, cancel.
So what the court will do now?
Your Lordship, again they have called for it.
Cause of action.
I am participating, Your Lordship, because now citing a reason, they should have a logical conclusion to it, because it cannot be that for 2024 till 2025, tender will be called multiple times and they will never give a reason for that. I am before Your Lordship to kindly ascertain that why this administrative purpose will be done. Because my submission is that on averment I have said that there is an excess going on where there are certain public, Your Lordship, they don't have a license to operate.
Have they allowed any persons to continue with this stall or whatever it may be?
They're not disclosing that, Your Lordship.
Disclosing, there will be stall. You can identify there are stalls.
Your Lordship, if they are not allowing me to participate in the tender, and how can that? That's why initially I submitted to Your Lordship letter.
What is the tender for?
Tender is for 2 purposes, Your Lordship. One is from ice cream kiosk, and other for the food.
That's why ice cream kiosk and food.
Yes, Your Lordship.
Food stall.
Yes, Your Lordship.
Ice cream stall and the food stall will be appearing by open eye if
Yes.
they are running the business on
Yes, Your Lordship.
in question. So whether any person is running the business over the
Yes, that I cannot disclose. That I have no information. That they will be in a better position, because I am putting an allegation that if there is, Your Lordship, kindly appreciate one thing.
He is running the shop at present.
That the authorities can say, Your Lordship.
Your allegation where
Yes, that I can show.
Some person is running the running the ice cream parlor without and they have allowed without the process of law. Where is that?
That is in my representation at page.
Not representation. Show me the pleading.
Yes, sir.
What is the case you have made out?
That is there, Your Lordship.
Para 6 onwards.
There are various miscreants who are illegally occupying the space inside the Offset Zoological Garden and disturbing the harmony. Go to the public interest litigation. File a public interest
case
for the public interest litigation.
But this is more of a RTI than a litigation.
The petitioner has the grievance of the petitioner in the present writ application that the respondent authorities time and again issuing the tender notice for ice cream, for food and ice cream stalls at which place? At which place?
Alipur Zoo.
Alipur Zoo, Your Lordship.
Alipur Zoo. But
it's Zoological Garden, Alipur, Your Lordship.
But every time the authorities have cancelled the tender process with the on the ground of administrative reason. Administrative reason.
Page 29 annexed that, Your Lordship. Page 29.
On the ground of administrative reason. Counsel for the petitioner submits that the petitioner has made a representation to the authority to consider the representation of the petitioner and to complete the tender process so as to enable the petitioner to be participated in the tender process. This court find that though the authorities have issued the tender notices, but subsequently the same has been cancelled due to administrative reasons. Thus, this court did not find any reasons to did not find any merit in the writ application. Accordingly, the writ application is dismissed. However, the dismissal of the writ petition will not prevent the petitioner to take to challenge any further cause of action in future.
Deeply appreciated.
Obliged.
So disposal note. Rejected, let the matter appear on 10th of April. Let the matter appear on 12th January under the new motion.
I am appearing for the state of the I am appearing for the state of the Good.
You then.
Obliged.
Yes, Mr. Sarkar, which matter?
Next matter, my lord.
Boundary wall is over. Yes, what is any matter? Urgent?
Well, may I believe Lordship to mention urgent matter, my lord?
Sir, Chulse matter.
Which 21?
21, Lordship.
I appear for the private respondents, my lord. I think there is some, not so sure, your lordship will see the array of the state respondents. Whether your lordship would take up this matter, my lord, determination wise, I'm a bit.
Land record.
Land.
Yes, Mr. Sarkar.
Well,
Land and police.
both. We are
Neither I am having land nor I am having police.
my lord.
Without police, without land.
Lordship, he's trying to confuse anyway.
I'm not trying. I'm just showing the cost title.
My lord, this is to the petitioner is making a first private township in West Bengal in 15 acres of land.
I have some issues on maintainability if I learn it from.
This court is having the determination. How?
Well, there is a paragraph 42 and 43.
What is the prayer?
Kindly see the prayers, my lord.
Erect and mark the cost of
Paragraph 11, Lordship sees at page 3, paragraph 11 on.
Copy them.
Partition
of a land will take place without land determination.
It is a multifarious cause of action. So,
so you choose to court number 25.
Joinder of causes of action.
It's better to go before a smiling judge.
Interlocutory court, joinder of causes of action. This has become, my lord.
So, paragraph 11 and 12, very clearly later, my lord.
30. 12, 30, 11 to 30.
Yes.
Paragraph 13 in particular says.
There's no overlap. Both don't have. Both is not. There's no overlap.
Releasing, I am ready.
Yes.
So what happens when a big project comes up, vultures pumps in?
Go to the appropriate court. I don't think.
Lordship, can you give me a minute? There is a multifarious jurisdiction involved. Everybody will throw me out, but 2 days left. Where shall I go? Lordship, can you consider this? And after all I say that there is apprehension of breach of peace. So let and the government has published in its website that they will demarcate land upon payment of charges specified in the notification. All I say, let them demarcate. And I have a boundary dispute allegedly with my private response, they alleged to be. And my lord, the anti-socials are coming into my project, stopping the workers and all. There is a apprehension of breach of peace, one thing. Second is, if they demarcate the land, my lord, at my cost, they are.
This court cannot pass an order on the land of the retreat.
It is there. It says that
Lordship has seen that in a given case, there may be overlapping of the subjects as classified by the REIT rules. There may be in given case an overlap matters related to panchayat and land, or be it a residuary matter and land. There is such reputation as dominus litis would be entitled to choose between the overlapping groups. Correctness of classification of reputation in a group under the REIT rules would depend on facts and circumstances of each case. So,
either police or land. One of police or land. With the greatest of respect, my lord, perhaps.
This is nothing to do with land. It is land survey. Land survey doesn't fall under land, my lord.
Appellate side list देखे बोला नहीं.
Land survey, land comes under Land Reforms Act, and we are asking under the Survey Act. Lordship, all I say, Lordship, look at the prayer straight away. At page 25.
two courts of concurrent jurisdiction, you can approach one court. But with the greatest of respect, this court doesn't have jurisdiction either over land or police. Except police. Except police.
Excluding police.
Determination is excluding police. Okay, anyway, my objection may be recorded. We'll deal with the matter on merits. There's no difficulty.
My lord, when we have no answer on merits, we take the point of jurisdiction. Of course, my lord, I don't blame my learned friends here. The state has to answer.
It is better. I am releasing, I am giving a liberty to mention Monday on the appropriate court. This is better.
Lordship has seen that we can choose.
But under which either land,
It's not. It is not. My both are needed. It's not that. Lordship, look at the circulars. Circulars are by the survey department. Survey department doesn't fall under land. Survey department doesn't fall under police.
Survey department functions under the land and land reforms department.
And Lordship,
and under the land department and is regulated and managed by the land department.
yes, of course. Land department, this is under Bengal Survey Act. They'll be acting.
Why I am saying the authority is the district. Well, kindly come to their cost title. They have added.
correct. That's why
That's all that I said. Kindly see the cost title.
Directorate of Land Revenue Services. Kindly come to
Actually,
cost title, respondent number.
Kindly see serial 1, Principal Secretary, Land and Land Revenue.
that
revenue.
petitioner is not having the this court is not having the determination in the present application. Accordingly, the writ petition is released from the list of the case and list of this court with the liberty to the parties to mention before the appropriate court having the determination.
Grateful, Malad.
Malad, this is the
Malad,
law
kindly
under which
record it.
they will function. This
Malad,
is
this- I'm for the
Arey,
state, Malad.
release kore.
release করে দিয়ে একটু দিয়ে
Yes, call.
Malad, this is the law under which they will act.
Actually, state report लेके आया है.
इतना जल्दी बिना रिट हियरिंग में
बिना admission.
Reported copy দিয়ে দিন না, দিলে হয়।
না, আমি দিতে পারবো না. বলে দিন, Lordship.
Malad, the state have come with a report. May I have a copy?
What next?
The state has come with a report. May I have a copy, my lord?
Before the writ is admitted, the state has come with a report.
Yes,
That's what happened. Cost matter, your lordship would have seen, state has come with
Well,
a report.
how a private respondent is so worried, so worried.
Before appropriate court, you file it.
If you can give a copy, it will be easier.
You, as a friend, you can give it. Not
Without order, I can't, man.
not at the order of the court. Yes.
My lord, may I believe my lordship to mention this matter, my lord? That is, that is, my lord, this matter is, my lord, that is very important, my lord. That is on 31st of October, that was heard by your lordship, my lord. And a lot of litigation has been done. Due to that reason, at least subject, let it appear as to be mentioned on Monday, my lordship, please.
Matter.
Matter is, my lord, 31st of August, that was heard by lordship, my lord. And the alleged count number 1 to 6 were brought on arrest, my lord. And they requested by lordship that they shall file the affidavit by 10th of November, but they failed, my lord. Due to that reason, my lord, I am suffering, my lord. At least let it appear to be mentioned on Monday, my lord.
Preparing for?
Petitioner.
It's a contempt matter. Contempt matter laga do.
Lordship can make it not under the heading to be mentioned, my lord, on Monday. That is item 38 today, my lord.
Correct. It will come as a contempt matter.
Contempt matter, that is appearing under heading.
What is the urgency?
Urgency is, my lord, that, my lord, we are getting nothing, my lord. They were brought on arrest on 31st. They were directed, they failed on 4th occasion to file any affidavit compliance, my lord. That is the certificate.
After vacation, I will see.
My lord, at least subject.
Come after vacation, I will see. Yes, call.
My lord, may I be permitted to mention, my lord, item number 23 of my lord's list today. My lord, the interim order is expiring today, my lord. This is a defamation suit where my lord had 23, my lord. My lord, the interim order is expiring today, my lord. The defamation suit, my lord,
Push to the other side.
My lord, I have given notice. My lord, Mr. Kakrani is here.
Though the matter is listed as item number 23. 23?
Yes, my lord, 23.
23. Mr. Learned Counsel for the petitioner prays for extension of the interim. According entry body is extended till 22nd of January 2026 or until further order.
My lord, will kindly post it after 26th, my lord, after 26th of January, the interim order.
20th January.
My lord.
Well, may I have your lordship's kind leave
And
to
my
mention
lord, the matter
for
will appear,
extension
my
of
lord, on.
well, may I have your lordship's kind leave to mention for extension of interim order, my lord, item numbers 71 and 72 of your lordship's list, my lord. 71 and 73. Mr. Ray is leading me, your lordship.
71
and 73, my lord.
Ah.
These are, my lord, section 9 applications, my lord, heard by your lordship, my lord. My lord, Mr. Ray, perhaps, my lord, was there on, my lord, the...
But I'm still there, my lord. I'm opposing, my lord.
Yes, my lord.
Not the extension. Now, my lord.
71 and 73.
73, my lord.
So in which both the interim order is there?
No, my lord, 73. In 73, the interim order was, my lord, subsisting.
Yes, Mr.
My lord, I'm opposing. I'll leave it to your lordship, my lord.
Though the matter is listed as item number 73, but the Learned Counsel for the petitioner mentioned the matter for extension of interim order. Learned Counsel for the respondent raised objection for extension of the interim order. So finally, the petitioner is already enjoying the interim order, and for the interest of justice, the interim order is extended till 22nd of January 2026 or until further order, whichever is earlier. Let the matter remain in the list.
And I was only beseeching your lordship only once, my lord. May I just point out, my lord, if I'm not there in the first week, my lord, kindly allows me an adjournment, my lord. I wouldn't be there.
But then in that even, my lord, kindly
first
keeps it,
week,
my lord,
my
in the second week of, my lord, January.
Can I fix the matter for hearing in the February?
Yes, my lord.
That will be better. So hearing.
Yes,
can,
yes.
matter
Yes,
can-
yes, my lord. I'm ready for hearing, my lord.
Let the matter up.
My lord, it is, my lord, our section 9 application which your lordship was hearing, my lord. So we have completed our submissions, my lord, so far as, my lord, the petitioner is concerned in, my lord, both the applications, especially in AP 91. My lord,
In the month of February.
if your lordship kindly, my lord, keeps it, my lord, sometime, my lord, in second week of January, my lord, well, thereafter, my lord, in that even, my lord, kindly extend the interim order also.
Yes, yes.
Very
Interim order till that day.
Very-
Both the application be remain in the list.
Very well. Very
Let
Grateful,
them
my lord.
appear on 9th February 2020 at 3 p.m.
I'm so grateful.
Very grateful.
Let this matter be appeared along with AP Com 91 of 2020.
And one of the interim order is also, my lord, extended. My lord. Interim order, my lord, which is in AP 90, item number 73, my lord.
That's the extended.
That is
The
also.
order extended till
But you see,
9th of
OCC
February.
also,
मुझे ऊपर बोला ना उसको हटा के 9th February का.
I'm so grateful.
The interim order is expiring today.
Grateful.
Matter also, I was bringing it.
Well, only one indulgence, my lord.
It can be fixed, your lordship.
My lord, only one indulgence, my lord. Item 22.
No, item 4, identical. Given your lordship.
Identical.
It will be fixed, your lordship. Any.
Today, I will take today itself.
My lord, identical prayer for item number 13 and 14.
Item number 14.
14.
14.
The interim order is
Prayer
expiring
made by
today,
the
my
council
lord.
for the which matter?
My lord, this is that matter wherein my lord was pleased
So
to.
the prayer made by the council for the plaintiff interim order is extended till 23rd of January 2026 or until further order, whichever is earlier, except respondent number 6 and 7.
My lord. My lord. My lord.
It can be fixed, your lordship. If it is in February also, let it be.
Other side is not there.
My lord, we are.
Your lordship, I am for the defendants 13 and 14 in item number 14, your lordship. If the interim order is extended, I don't think I have a problem. Your lordship can fix the matter.
Let the matter appear on 11th of February 2026 at 3 p.m. Interim order extended till 11th February 2026.
Obliged, my
Per card dena.
only one indulgence, my lord. Appellate side, item number 22. My lord, this is against the Serious Fraud Investigating Agency. My lordship was pleased to take up the matter on 11th of December. My lord, the SFIO was required to file the lookout circulars. Yes, item number. This is the last order that was passed. Yes, my learned friend is appearing for the SFIO.
Appellate side.
Yes, appellate side. My lord, only difficulty is, my lord, I am, my lord, making endeavors to travel, but only, my lord, because there are subsisting lookout circulars, my lord, I am not being able to, my lord, that's the obstacle. My lord, today, my lord, I know there is a paucity of time. My lord, Monday we can come back if lordship will kindly accommodate us on Monday, my lord.
See, I will put the date as a urgent motion, but I can't assure when it will be
No,
taken.
if-
Because see, all the matter I'm fixing urgent motion, I am not reaching up to 20.
My lord is reaching. Sometimes I am not reaching.
That is your luck. That is your luck.
My hard luck, lordship, because that day, my lord, what happened, I was waiting in this honorable court since morning. All of a sudden, the matter was that I missed the bus, lordship. So, my lord, I have no issue.
No.
Whatever my lord died.
Now before vacation, then now the slow, because all matter is taking up.
By any day, my lord, if it can be.
इसको ना 20 Monday urgent motion में रख दो. Urgent motion अच्छी.
By any,
वाला matter, वाला matter 2 बजे
by some precedence in your lordship's list, if they.
10 के अंदर रख.
Great.
With your kind leave, Lordship, I understand there's a fixed matter and I may not get a turn. Item number 8 of my Lord's list. It's only for clarification, Lordship. I had mentioned the matter. My Lord had said because it's a probate matter, it's better if I come up with an application. Lordship, the death certificate, the probate was granted by my Lord, but the death certificate of the person who died, the Hindi translation changed his surname, Lordship. So he's Birendranath Moitro, but the translation done, it is written Moikhya. I have annexed the death certificate and the translated copy. I would only praying for a clarificatory order and I could make the corrections in the department in the translated copy. The probate has already been granted. I'm getting stuck in obtaining it.
The other
Lordship.
side.
It's an uncontested probate, Lordship. Already granted, only receiving is getting stuck because of this, Lordship. GA1, Lordship.
Monday to be mentioned.
Grateful, my lord. Grateful.
Lordship, this is a suit for eviction. My interim order is expiring today. I've given notice to the other side.
Suit before this court.
Lordship, this is a part heard matter, specially assigned.
It is not in the list.
It is there. Item number 63 of today's list.
You are for the plaintiff.
Yes, Lordship, I'm for the plea.
So the matter is listed as item number 63.
Yes, Lordship, 63.
But learned counsel for the petitioner plaintiff has mentioned the matter on the ground that the interim order is still today and prayed for extension of interim order. In view of the submission made by the counsel for the petitioner plaintiff, the interim order is extended till 27th of January 2026 or until further order, whichever is earlier, let the matter remain in the list.
My problem.
Yes, call the. You will get only 10 minutes.
Yes, my lord, we'll make progress, my lord. That's my lord. Now, my lord, I had shown your lordships, my lord, the appraisal note, my lord, chart in the reply, my lord, to the show cause notice.
No, तो chart था नहीं.
जाओ chart था दाओ जरा करके. This is what we had given yesterday.
You show us the chart from the show cause.
My lord, in the show cause notice, my lord, your lordship will kindly come to, my lord, the reply, my lord, to, my lord, the show cause notice.
Yes.
My lord, we had, my lord, set out the chart at page 128, my lord. My lord, writ petition, volume 1, page 128.
Yes.
Now, my lord, what I had, my lord, tried to impress upon your lordship was that, my lord, the 2 years, my lord, for which, my lord, they say that we are in willful default, my lord, because, my lord, we diverted funds to our group companies, my lord, the entire thing, right from, my lord, 2014-15 onwards, my lord, right up to 2017-18, my lord, they had been disclosed in our annual accounts. My lord, accounts were appraised by the consortium of banks, and the appraisal notes specifically, my lord, said, my lord, that our position, my lord, was fully acceptable and recognized these investments my lord, as strategic investments, because my lord, we are into, my lord, the business of building infrastructure. For each project we have, my lord, we set up a special purpose, my lord, vehicle. Now, my lord, I want to show your lordship now, my lord, the appraisal notes themselves. My lord, kindly take, my lord, the appraisal note of 2017-18. My lord, I'll show your lordships, my lord, first. Page, my lord, 198.
Second volume, the
My lord, this is volume 2, page 198.
yes.
Kindly come to, my lord, page 213.
Yes.
My lord, your lordship has, my lord, the heading, my lord, item, my lord, 13.
Details, yes.
Details of intercompany transactions, investments, if any. Answer is yes. If yes, whether banks, our bank facility was used for the purpose. As on 31st March 2017, the investment and loans and advances in associate subsidiaries was rupees 65.19 crore and rupees 23.21 crores respectively, which has reduced from 75.98 crores and rupees 35.61 crore as on 31st March 2016 respectively. All these investments and loans and advances extended towards associate subsidiaries are strategic in nature and is considered acceptable. Now, Millard, kindly come to Millard. What about this? Millard, kindly come to page 234. Now, Millard. 234. Millard, kindly see, Millard, the heading 33, comments on.
Yes.
Now, Millard, your lordship says default/willful default and any other unsatisfactory features in conduct of accounts with us/other banks on institutions or institutions. The conduct of the account is satisfactory. There is no instance of devolvement of letters of credit and invocation of bank guarantees ever. So, my lord, even under willful default, specific attention, my lord, being drawn. My lord, the bank says, my lord, it is, my lord, fine.
Yes.
Now, my lord, kindly come to, my lord, the appraisal note for 2016-17. My lord, it starts, my lord, at page 299. Lordship will find. My lord, this is the lead bank, State Bank of India.
Yes.
And, my lord, your lordships will find, my lord, EMC Limited process notes of working capital assessment. Kindly come to 311. Third volume, my lord, volume 3, 311. My lord, this is their note, my lord. Details of, I'm sorry, my lord, 311. Details of intercompany transactions/investments, if any. Yes, if yes, whether banks, our bank facility was used for the purpose, though the investments and loans and advances in associates, subsidiaries, JVs, joint ventures as on 31st March has increased by thus. The investments in group companies has increased from so-and-so to so-and-so for this financial year. Then comments on sundry debtors beyond 6 months. Present position in financial year so constitutes so-and-so. It has increased by so-and-so in financial year on year-on-year basis, which consists mostly retention money of completed projects. The reason for such increase in debtors exceeding 6 months is some of the major projects of the company have been completed in 2016, but retention money is generally realized after a period of 6 to 12 months as per contract terms. Well, now kindly see, this is usual in case of a EPC contractor, because our business is EPC, engineer, procure, and my lord construct. Now, my lord, kindly see 6 loans and advances to group companies. The loans and advances extended to associate subsidiaries has increased from so-and-so to so-and-so. Overall increase in investment loans and advances in associates and subsidiaries of so-and-so and so-and-so is strategic in nature and is considered acceptable. Then, my lord, what? Now, my lord, one other, my lord, because there's specifically, my lord, on McNally Bharat, there is, my lord, your lordship will find, my lord, others, if any, because this has been made, my lord, a particular ground, my lord, in, my lord, the show cause notice. EMC has made a strategic investment of 142.88 crores in McNally Bharat Engineering by availing long-term loan from IFCI Limited in order to gain substantial synergic benefits coupled with enhanced ability to provide integrated engineering, electrical and turnkey solutions for its customers. No objection. Now, my lord, page 331.
Yes.
In fact, my lord, 330, if your lordship kindly starts with, comments on
Yes.
borrower default, willful default, and other unsatisfactory features in conduct of account with us, other banks, institutions. The conduct of the account is satisfactory with our bank. Payment of interest is regular, and there are no devolvement of LCs and invocation of bank guarantees, so and so. However, sometimes there is delay in payment of interest with some of the lenders, and on few occasions there were instances of LC devolvement with some of the lenders in the consortium. Such delay in payment of interest was due to occasional mismatch in cash flow in general and delay in realization of projects in Bihar due to flood and political unrest in Jammu and Kashmir in particular. The situation has now changed and cash flow has since improved. The conduct of the account has also improved since then. No issue regarding diversion. Now, my lord, kindly take, my lord, page, my lord, 386. My lord, this is part of, my lord, the appraisal of 2015-16, which starts from page 370.
Yes.
Then, my lord, kindly have a look, my lord, at clause 6 at the bottom. Loans and advances to subsidiary companies have decreased by rupees so and so, from so and so, so and so, so and so, etc. Then, my lord, at the bottom, all these advances to its subsidiary companies are strategic in nature and in line with the stipulations made by the bank. Then, my lord, kindly come to page 388, my lord.
Yes.
My lord, the last 5 lines, my lord, after, my lord, the funds, my lord, investments in subsidiaries, etc. Kindly, my lord, see, my lord, last 3 lines. With increase in business volume and increase of loans to related parties by 15 crores, there is no diversion of short-term funds for long-term use. Position may be considered as acceptable. My lord, then 404 also your lordship will find. My lord, just above the table, the overall increase in investment is compensated by infusion, etc. and condition so and so is investment in associates to be capped at 20%. This is the lead bank, my lord, conditions which are being dealt with. Then, my lord, kindly come to 1415, which starts at 443. Then at, my lord, page 451, kindly, my lord, take 451 to further expand its, my lord, the third para. To further expand, lordship has that, my lord. Its global presence, company has established 3 new subsidiaries in Dubai, Singapore and Hong Kong. Dubai subsidiary was already in operation and subsidiaries in Singapore are expected to start shortly. During the last financial year, company has also taken over Quattro Rail, who are specialized in railway signaling and electrification, and one existing running power grid approved tar manufacturing unit in Raipur. So, my lord, expansion of business. Then, my lord, kindly come to 459. Yes. Then, my lord, kindly see EMC continues to invest in smaller units, both domestic and foreign, with similar business interests during last year from cash accruals of the business. EMC has acquired, my lord, all that is, my lord, mentioned here. And, my lord, lastly, my lord, your lordship will find that during current year, where is that gone?
Next, 460.
And, my lord, at 460, my lord, your lordship will find in, my lord, last three lines. In current year, long-term sources are estimated to increase. During current and next year, there is no diversion of short-term funds envisaged for long-term uses. Position may be considered as acceptable. And, my lord, just as an example, my lord, that's there in, my lord, all, my lord, the appraisal notes. My lord, kindly take page 198 once. Lordship will find, my lord, in the second last row, my lord, of volume 2, my lord, page 198. My lord, second last at the top of the letter.
Yes.
My lord, second last row, second last column, IDBI Bank, my lord, is, my lord, shown. IDBI Bank Limited, IDBI. Lordship has that.
98, 198.
198, my lord. My lord, at the start of the letter, there is a table.
Yes.
My lord, it's a SBI letter.
Correct.
My lord, it starts with Allahabad Bank, Punjab Bank. Kindly come to, my lord, the fourth row.
Yes.
And, my lord, come to the second last column.
Yes.
In the consortium, my lord, IDBI is also present.
Yes. Good. Yes.
Now, my lord, so and, my lord, this was, my lord, annexed, my lord, in the reply to our show cause note, our reply to the show cause notice, and, my lord, which was not considered at all. Now, my lord, kindly come to, my lord, the master circular once. Volume 4 starts at page 558. My lord, of 1st of July 2015.
Yes.
Now, my lord, kindly take the definition, my lord, of willful default. My lord, clause 2 at 561. My lord, it's guidelines on, I'm sorry. Guidelines on willful defaulters. Definition of lender, unit, and willful default. Kindly come to willful default 2.1.3. A willful default would be deemed to have occurred if any of the following events is noted. The unit has defaulted in meeting its payment repayment obligations to the lender, even when it has the capacity to honor the said obligation. So, my lord, they are solvent. Instead of, my lord, paying, my lord, the lender, having the capacity to pay, they are not paying. Then, my lord, B, the unit has defaulted in meeting repayment obligations to the lender and has not utilized the finance for the lender from the lender for the specific purposes for which finance was availed of, but has diverted the funds for other purposes. Now, my lord, kindly have a look at 2.2, because they are, my lord, on diversion of funds. 2.2, my lord, the term diversion of funds referred to in paragraph 2.1.3b above should be construed to include any one of the undernoted occurrences. My lord, they, my lord, base their case on C, D, and E. transferring borrowed funds to the subsidiaries, group companies, or other corporates by whatever modalities. Then D, routing of funds through any bank other than the lender bank or members of consortium, kindly mark, my lord, the words, without prior permission of the lender. And my lord, E, investments in other companies by way of acquiring equities, debt instruments without approval of lenders. Now, my lord, what has been, my lord, argued, and my lord, the point, my lord, which has been taken is, please forget breach of principles of natural justice. This is a case where the order of willful default is like a judgment on admission. Now, my lord, why do they say so? Because, my lord, it's an admitted fact that, my lord, we have given funds to, my lord, group companies, including McNally, my lord, which I pointed out to your lordship, which is the main subject matter of the show cause notice. Now here, my lord, I wish to, my lord, deal with this, my lord, issue. First, my lord, is the basis of this, my lord, are two sanction letters. My lord, one of August 26, 2018, and my lord, the other is of October 18, 2017. My lord, kindly have a look.
First letter dated?
26th August 2016.
Yes.
Which your lordship, my lord, will find at page 32 of the affidavit in opposition.
Yes.
Kindly have a look at, my lord, the date. August 26, 2016. Yes, my lord, kindly come to, this is the sanction letter of IDBI. Kindly come to, my lord, page 40, my lord.
Yes.
My lord, it says, my lord, other terms and conditions, kindly come to D. 2, my lord, D. The company shall utilize the sanctioned working capital limit for intended purpose only and shall not utilize, kindly see D, for extending loans to subsidiaries or associate companies or making any intercorporate deposit and any other purpose. So they say, look, you have violated this. Therefore, you're liable. Now, my lord, the important thing is, my lord, that I could deviate from this. Your lordship has seen, my lord, your lordship will see, my lord, first, my lord, before this, my lord, this condition can't stand in the way because, my lord, we had, my lord, if your lordship sees the investments, they are before the sanction letter, my lord, which is at page, volume 1, page 127. This is again, my lord, a reply to the show cause notice.
Yes.
My lord, other than, my lord, the fund, my lord, of 0.37, your lordship seen, my lord, the table. My lord, if all the investments, my lord, had been made, my lord, prior to, my lord, 1718, other than 0.37 crores, that's 37 lakhs. Lordship sees the table, my lord.
Yes. Total 0.37
is only in 1780. Everything is before the sanction letter. So my first submission is, reliance on this is wholly misplaced. To start with, it doesn't find, my lord, place in, my lord, the order. Second, it's introduced in the affidavit. Third, my lord, clause D could not have applied to, my lord, loans, my lord, given, my lord, prior. Number 2, appraisal notes have shown your lordship. My lord, these, my lord, diversions, if any, my lord, have been, my lord, found to be acceptable and recognized, my lord, to be for the benefit of the company. Now, my lord, kindly come to the next sanction letter. My lord, page 43. My lord, of, my lord, the affidavit in opposition. My lord, kindly come to, my lord, page 49.
Yes.
My lord, 9, the company should obtain, my lord, clause 9, my lord, other terms and conditions. The company should obtain prior approval from the lenders before making
Investigation.
any further investments in group company subsidiaries. Again, my lord, if your lordship goes to the chart, my lord, it's only that 0.37.
Yes.
And my lord, this is also in the appraisal note, which I showed your lordship. Again, my lord, same point. But my lord, more importantly, my lord, kindly have a look, my lord, at, my lord, which I showed your lordship, my lord, the circular, master circular. My lord, page, my lord, 562, volume 4 of the writ petition.
Yes.
Now, my lord, investments in other companies by way of acquiring equities, debt instruments without approval of lenders. Now, my lord, very important thing is the circular itself, my lord, does not use the expression prior.
Investment in other companies by way of acquiring equities, like debt investments
Without approval. It doesn't use the word prior. My lord, the previous clause, kindly look at D, routing of funds through any bank other than the lender bank or members of consortium without prior permission of the lender. So the word prior is not there. My lord, my main point is you have given permission by the appraisal note. You have given approval by the appraisal note. Now, my lord, this is supported, my lord, by the law as well. My lord, my lord, what you've given, just escorts.
Yes.
Now, my lord, kindly consider the decision, my lord, in, just let me do it now. My lord, 1986, one Supreme Court cases, 264. '86, 1, 6 SCC, 264.
Yes.
LIC versus escorts. My lord, kindly take paragraph 61 and 62, my lord. My lord, the Foreign Exchange Regulation Act, my lord, had, my lord, certain similar provisions. Now, my lord, kindly come to paragraph 61 first, my lord. From what has been narrated above, one of the principal questions to be considered is seen to be whether the Reserve Bank of India had the power or authority to give ex post facto permission under section 29(1)(b) of the Foreign Exchange Regulation Act for the purchase of shares in India by a company not incorporated in India, or whether such permission had necessarily to be previous permission. Now, my lord, kindly see. We do not propose to refer to any dictionary to find out the meaning of the word permission, whether the word is comprehensive enough to include subsequent permission. We will only refer to what Sir Shah Suleiman, Chief Justice of the Allahabad High Court, said in Shakir Hussain and Chandulal. Ordinarily, the difference between approval and permission is that in the first, the act holds good until disapproved. So, my lord, we are concerned with the master circular here. Master circular uses the word approval. If I have done it, my lord, it should be disapproved immediately and not approved in the appraisal note. So, my lord, what does it say? Between approval and permission is that in the first, the act holds good until disapproved, while in the other case, it does not become effective until permission is obtained. But the permission subsequently obtained may all the same validate the previous act. So, my lord, whether permission or approval, my lord, ex post facto, my lord, it could have been validated. But for approval, my lord, where, my lord, the master, because I have to be declared a willful defaulter under the circular. Circular says without approval. That approval means, my lord, it's when the act is done, unless disapproved, it means you have the approval. And here there's an overt act on their part in the appraisal note.
Who will disapprove?
My lord, the bank.
So disapproved when they have declared as a willful defaulter because it is disapproved.
But before, when the transaction happened,
That is
I disclosed to them.
okay.
They had an appraisal of that transaction.
So you're
Correct. Your Lordship, absolutely. After having done that, there's no question, my lord, of then saying, my lord, that I am, my lord, a willful defaulter. My lord, I could have understood accounts had not been given. Or, my lord, there was in the first appraisal, they said, sorry, I disapprove of this. And immediately issue me, my lord, a notice to show cause. Now, my lord, I'll cite, my lord, one decision, my lord, of the Delhi High Court, my lord, which is reported in 2024, SCC Online Delhi 1516. My lord, identical situation, appraisal notes. And my lord, the court said, sorry, you can't declare them a willful defaulter. You have approved.
So your argument is that once the appraisal
Correct.
report which they have accepted,
Yeah.
subsequently you cannot.
Correct.
Then you will.
Because, my lord, then, my lord, it was, my lord, approved, found to be acceptable, not classified as diversion. I showed your lordship comments on willful default. None. And, my lord, that approval, there was no disapproval when disclosed to them. So, my lord, as per the law approved by the Supreme Court, my lord, the act is valid unless disapproved. And immediately, my lord, they, my lord, accepted. And these are all old loans, which are showing, my lord, an investments from 2012.
Okay.
Got it? My lord, kindly take 2024 SCC Online Delhi 1516. My lord, may I indicate the para numbers, my lord, first? Para 132, 134, 135, and, my lord, 156 and 157. My lord, kindly have a look at 134.
Yes.
Sorry, 132. My lord, it's print page 52, my lord.
Got it.
The learned counsel for the respondent bank has contended that MBIL did not take prior approval before making the investment in its subsidiaries. This court is not impressed with that said argument. As discussed earlier, the respondent bank and other lenders were always aware of these investments No document has been brought to the notice of this court wherein the lender banks raised any objection to these investments at any stage. On the contrary, the FRS of lender banks appreciated the nature of these investments and found them to be potentially financially sound. Further, the question for seeking prior approval could only arise, etc. Then, my lord, 134, the identification committee and the review committee of the respondent bank has held that the investments in subsidiaries triggered a shortage of capital and therefore act of investment falls in the diversion as per RBI guideline. Now, my lord, kindly note here, no such finding in this case. We are on a better footing. Then, my lord, 135. Learned counsel for petitioner contended that the aforesaid observation is totally misconceived and ignores the contents of so-and-so, etc. My lord, then, my lord, kindly come, my lord, write to, my lord, the bottom of that paragraph, last 6 lines. Thus, according to lender banks, the investments at the time when made were strategic, had growth potential and expected profits. However, when the investments did not yield profits due to various factors, they were subsequently categorized as diversion, siphoning. Such an approach cannot be countenanced in any, then my lord, that's borrowed funds, etc. Then, my lord, kindly come to, my lord, 156, which is, my lord, the main one. Main, my lord, paragraph which I wish to rely on, 156 and 157. In the present case, the lender banks were aware of the investments made by so-and-so in its subsidiaries. This fact is part of the documents leading to the finalization of the CDR scheme. The investments were treated as strategic with growth potential and expected profits. The investments were found to have been made from cash surpluses. Lender banks did not find these investments as diversion or siphoning of borrowed funds. Lender banks placed MBIL in class B so-and-so, which cannot be assigned to it if there's diversion. They found no occasion to order a forensic audit either before finalization or after. Lender banks, therefore, never treated the investments in subsidiaries as an act of diversion or siphoning, either during finalization of CDR scheme or after its failure. In view of the aforesaid reasons assigned in the impugned order passed by review committee as willful defaulter and therefore is quashed and set aside. Now, my lord, here what is our case? First, the constitution is bad. I've shown your lordship. Second, my lord, in any view of the matter, the order, reasoned order, has not been passed by the committee. They just confirmed the decision of the identification committee. Third, there's complete non-application of mine. My lord, their observations are the submissions of the dealing group. It's not even of the identification committee. Correct. Now, my lord, I had replied to the show cause notice to, my lord, the identification committee. They had not dealt with it. I had pointed that out, my lord, in my representation to the review committee. My lord, giving, my lord, my responses to the show cause notice. They were, my lord, not dealt with at all. There's, my lord, nothing, my lord, to show, my lord, that this has been dealt with. In fact, my lord, there are 2 portions of the order, my lord, which I wish to show your lordships. My lord, page 556, 555 and 556. My lord, volume 4. My lord, yesterday, my lord, I had pointed out clause 5. Yes. My lord, where, my lord, because it's a cut paste and no application of mine, my lord, dealing group, my lord, in response to our letter, second line, correct, conveying the decision so-and-so. Then, my lord, kindly see, last sentence of that subclause. No additional justification have been provided by them. Our justification has not even been considered. Then, my lord, kindly come to, my lord, next page. First paragraph. WDRC carefully examined the contents of the written representation received in response to the order of the Willful Defaulter Committee dated January 11 and observed that the written representation have not brought out any new fact, law or material that has the nature of changing the decision of Willful Defaulters Committee of bank to declare them as willful defaulter. The response does not comprehensively cover all the grounds on which proposal for declaration of was based and further contents are not supported by facts and record. In view of this, after thorough so-and-so of the records, in response is of the opinion that promoters, etc. Now, my lord, with the greatest of respect, my lord, this is not, my lord, how the jurisdiction is to be exercised. JAR developers specifically said, Supreme Court, that the representation that we give, my lord, fully considered, my lord, and my lord, here, my lord, it's not even, my lord, considered at all. Anything else? My lord, I think I have concluded, my lord. I'm grateful, my lord.
Thank you.
So there are total 5 petitions. Mr. Mukherjee has addressed your lordship on item number 1.
Yes.
I will trouble your lordship for item number 2 and 3, and Mr. Sen is there for 4 and 5.
5 is Mr. Datto. Mr. Ragoshi Datto is leading me for 5, which is an additional point we have. Other points are the common points which have already been.
My lord, in my other one matter, my lord, the interim order is to be extended, my lord. This is item number
Just
4.
let this order. Learned counsel for the petitioner. In WPO 424 of 2024 is concluded his argument. So respondents will give their reply to all together.
Yes.
Let the petitions complete. Full stop. Let the matter appear. क्या होएगा? Three? 20 January. 22nd January, 3 p.m.
My lord, except 20th, 21st and 22nd of January, any day.
So let the other part, Mr. Sen, continue.
So your lordship is giving any
20 and 22nd.
20 and
You will not be there.
I will not be there.
I shouldn't take long because Mr. Mukherjee has made exhaustive submission, my lord. So lordship shouldn't give too much of time for all of us, my lord.
Particularly Mr. Bose.
3rd and 5th February.
Very well.
3rd and 5th February,
3rd
3
and
p.m.
5th.
Well, only item number 4 and 5.
3rd and 5th February at 3 p.m. Yes.
Item number 4 and 5, my lord, the interim order was still today.
4 and 5.
Yes.
In this.
See, same group. 520 and 521.
What about the other
Till disposal.
Till disposal.
Interim order still
Till
disposal.
This also may continue.
Yes, lordship will continue it till
The item number 3 and 4, learned counsel for the petition
4 and
submit that. 4 and 5. ठीक है? WPO 520 of 2024 and 521 20.
Yes.
Counsel for the petition press for extension of the interim order. This court find that the other petitioners are already enjoying the interim order till the disposal of the application. That the interim order is extended till the disposal of it.
All right.